Good morning to all. Thanks. I think I'm not audible to you. Okay.
No, you're audible very much.
Yeah.
We can hear you.
Good morning, everyone. And thanks for you all people. I know there's a long weekend with a festival mood and everyone is in a holiday mood, but still you people are joining. Really, really appreciate your all support. Thanks for that. We are really overwhelmed by this support. And thanks to Ms. Bala, who is veteran in this decided case. Let's accept that. And today our topic is analysis of adjudication orders passed by ROC, role of company secretary. We all are eager to listen, Mr. Bala. As I always do, I don't formally introduce Mr. Bala, but today I have to introduce you. Mr. Balakrishna is a company secretary having almost 4 decades of experience in secretarial compliances. He has worked with Foseco India Limited as a regular speaker at ICSI CCJRT. He regularly, I will say regularly means still today from starting, contribute various articles in various magazines, including Charter Secretary of ICSI. Friends, we always know any decided cases article, Mr. Bala is there to comment. So we thought that is the right person to talk on the topic and we wanted to have knowledge of his own. And so, Mr. Bala, you, I don't formally give his qualification as I always say, it is very difficult because it's very long. It will take 10 minutes to say his degrees. So with that, I will take it to Mr. Sudhakar to say a few words and then we will pass on to Mr. Bala to present his talk. Thank you.
Yeah, thank you, Dipti. Good morning, everyone. That Dipti has introduced Bala as I was mentioning just before starting this topic. I'm going to give him a title today to Professor Balakrishna. In fact, normally what happens is when a person of his stature, who is having 4.5 to 5 decades of experience in the profession, normally what we do is we call him as a Bhishma Pitamaha of the profession. No doubt about it. No doubt about it. He has been revered so in the past also. But the way he writes the articles and post it on all the social media, in fact, I find very difficult to read the articles, but he is not finding it to write the articles. I'm not able to keep the pace with him to read his articles. By the time I read one, he put 2 more, 3 more, 4 more like that, and he always keep me under stress. And I always say that when he can write like that, why can't you read? I'm still not able to make myself able enough, competent enough to keep the pace with him. I think sometimes, I doubt that even Vyasa Maharshi, who has written Mahabharata, he will be behind him only. So, apart from the Bhishma Pitamaha of the profession, I am going to give him a title today that he is also the Vyasa Maharshi of our profession. The amount of articles what he writes, nobody else can do that.
Yeah.
So, Bala sir, you are not only the Bhishma Pitamaha, you are the Vyasa Maharshi of our profession.
I am honored and delighted.
Thank you very much, sir. Now, today when the topic of we have chosen for analysis of adjudication orders passed by ROC. In fact, whenever I read Professor Bala's articles, the way the ROCs are penalizing the private limited companies and the closely held public companies, sometimes really my heart bleeds. I always think that who is the person responsible for this? Is it the promoter? Is it the director? Or is it the company secretary who is associated with them? Either in the service or in the practice. According to me, we are the culprits. It is not the promoter, it is not the directors, it is not the senior managements of these private limited companies or closely held public companies, but it is the company secretaries, whether in service or in practice. We have to call ourselves, with all due regards to all of you, I think that we are the culprits. I will say why it is so also. Whenever we talk about company secretary, what we say that we are the conscious keepers of the organization. We are the cultural ambassadors of the organization. We are the creators of the cultural the compliance culture in the organization. We are the governance professionals. We are the gatekeepers of the governance. We are the key managerial persons. We are the principal officers of the company. We are part of the senior management, irrespective of our organizational hierarchy as per the listing regulations. And we are in fact, we also say that, of course, several times I said this thing, ours is the only profession which gives the privilege to us to step into the boardroom right from day one, irrespective of our organizational hierarchical position. Despite all these things, if the organization suffers, then who is to be held responsible for that? That is what my question always is. The second thing is that day before yesterday, I have addressed the PSU directors, the independent directors who have nominated on the public sector undertakings. There were about 58 to 60 independent directors were there. This
Oh,
program was organized by Department of Public Enterprises at Varanasi. I was there. So that point of time, one third of the directors were appreciating the role of the company secretary in their respective organizations. But two-thirds of the companies, the independent directors were saying that the company secretary does not even talk to them, except that he sent the notice, he sent the agenda papers. If they ask any question, they may simply answer. But they don't take any kind of interest as far as the independent director is concerned. Now, one or two directors were quite vocal about one particular aspect. They say that, Mr. Sudhakar, you say that notice is to be given 7 days before. And you say that agenda papers are to be circulated 7 days before. But my problem is, I am from Bihar. That particular director was from Bihar, and another director was from, I think, UP, if I am not wrong. They say that we are from Hindi medium, and we don't know English. We can't read English. We may be able to understand a bit. And even the Prime Minister of our India, Mr. Narendra Modi, said that by whatever with the proceedings are there and all, it is to be done in Hindi, in the Hindi belt, in the companies or the organizations. And we asked the company secretary to give me the notice and agenda in Hindi, but it is not being done. Now, to whom we have to approach for that? Now, tell me that, don't you think that the company secretary has a responsibility to resolve this issue of the director? Because according to me, the company secretary says, sir, we cannot translate this into Hindi. That's what the answer I think he told me that the company secretary has given to him. I told him that don't agree with that. You take up the matter in your boardroom with the chairman, because it is their responsibility to provide you that. Now, sometimes, when I was discussing the same issue with another company secretary yesterday, that company secretary told me, "Sala, ye director kaise ban gaya hai without knowing English?" I said that, do you think that he is to be blamed or the company is to be blamed? When the government has nominated him as the independent director, and when the company's NRC committee has examined this thing, or the company was duty bound to accept him as the director, that point of time, they should have known definitely this thing, by that the gentleman has a communication issue as far as English is concerned. Now, having him on the director on the board of your company, if you give him a piece of paper which he can't read, how you are expecting him to perform as a director of your company? And these days, it is not that difficult also to translate that thing into Hindi. So by merely saying as a company secretary that, look, we cannot translate is not the answer. What I'm trying to say here is only one thing. Please don't misunderstand me. The company secretary's role is much beyond of simply ensuring the compliances or complying with the provisions of the act. I always say that company secretary is like a Parthasarthi for the board. He is the Lord Krishna. He is the charioteer. So his responsibility towards his directors is much more. He is the person who has to guide them. He is their guide. He is the philosopher. He is their friend. And he has to also tell them that what kind of difficulties they face, he should be in a position to resolve that. He is the bridge between the board as well as the management. So now the company secretary has to also educate the persons, because when I go as a faculty to the Institute of Directors, when I go as a faculty sometimes to train the directors, the first and foremost question I ask the independent directors in particular is, have you read Schedule 4 of the Companies Act 2013? Have you read Secretarial Standard 1 of the again issued by, by the Institute of Company Secretaries? They had no clue about it. Now, who is to be blamed for this? Is it the company secretary, or is it the chairman of the company, or is it the director himself? According to me, it is the company secretary. The company secretary has to sensitize the directors, especially the independent directors, about their duties, responsibilities, accountabilities, and whatever the legal provisions pertaining to them as the director. It is the responsibility of the company secretary to educate them, to sensitize them, to tell them that. Unfortunately, it is not happening. And it is the same thing, Noki, that whether you are in service or in practice, when you are in practice, you have to talk to your clients and you have to be vocal about this thing as far as the compliances are concerned. You cannot leave them. Several times when I talk to the company secretaries, especially in practice, they say, sir, हमारा client हमारा सुनता नहीं है. अरे भाई सुनता नहीं है मतलब क्या है? You have to take pains. एक बार बोलो, दो बार बोलो, 10 दफा बोलो उनको. You have to make your client to listen to you. You tell him the consequences. Then they will listen to you definitely. Show them the future. If you comply, okay, otherwise you are going to be down with so many thousands or so many lakhs, or sometimes you may have to attract the criminal provisions also. अगर आपका बच्चा खराब होता है, अगर आपका बच्चा आपको सुनता नहीं है, as a parent, what is your responsibility? Can you leave them? भाई मेरा बच्चा मेरा सुनता नहीं है, मैं क्या कर सकता हूं? Can we say that? Your children's future is the responsibility of the parents. Similarly, the responsibility of your clients. If you are a practicing company secretary, and the responsibility of your company, if you are in service of that company, is the company secretaries. So I want to give a pause. Definitely, the role of the company secretary in the coming years to be much more. The board is looking towards them. Wherever I go and address the independent directors, I tell them, catch hold of your company secretary. If he is not capable enough, you make him capable. At the same point of time, I also tell the independent directors to give necessary support to the company secretary, because I know that sometimes the management does not give that kind of an importance to the company secretary. I tell them very clearly that you have to support the company secretary. But at the same point of time, let me also tell you that the remaining 1/3 of the public sector undertaking independent directors, they were praising our profession, because they say that by my company's company secretary, he doesn't even bother. He tells the chairman very clearly that, look, as under the law, I have this responsibility. As directors, you people have this responsibility, and we have to abide by the law. I really happy about that particular thing. What I want to say is that 1/3 of the people are praising us, 2/3 of the people are not praising us. So we should be able to sustain that 1/3 appreciation, and we should get that appreciation from the remaining 2/3. So friends, I'm sure that whatever I said, it is coming from the bottom of my heart. It is not without, without any kind of malice. It is only for the betterment of the profession. Whatever I observe, I'm just told you all these things. So sometimes I feel that as a senior member of the profession, I do have to do some kind of a self-introspection periodically, which I do. At the same point of time, as a big brother, or as a senior, or as a mentor, whatever you may call me, sometimes I share my feelings with all of you. Wherever you feel like these are useful to you, please put it in practice. If you feel like this gentleman is very arrogant, please pardon. So I give a pause here, and now we are waiting to listen to Professor Balakrishna. Bala, stage is yours. Thank you very much. God bless.
Good morning to all of you.
Good morning, Mr. Bala. Good morning. Yeah.
I hope the screen is visible.
Yes,
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 sir.
sir.
Okay. Mr. Sudhakar has already said what we are, what is expected, what is the things are there. I will not get into those details very much. since my role is actually changed from the moderator to the presenter, I will straight away start with the presentation. Let us start with the small quote actually. Many of you may be knowing the management guru, Peter Drucker, who is recognized as a great management business guru. Many of you would have read his books on this. He says very clearly, doing the right thing is more important than doing the things right. Which means when we talk in our profession, efficiency and effectiveness, efficiency is doing the things right, whereas the effectiveness is doing the right things. Mr. Sudhakar also stressed upon this in the past also. Similarly, I also would recall what we call the Thiruvalluvar, who talks about a continuous learning, which goes back to the 1st century BC and 16th century AD. He writes only 1.5 lines, what is known as the couplets. There are many things which actually gives enormous meaning today, which is very much compatible with the Western world. I was just remembering, there is a small couplet, 1.5 lines. It is in Tamil. I will translate in English. It is actually said, Tottanai Thurum Manarkeni Mandarku Kattanai Thurum Arivu. If we simply translate this, it says, sandy soil, when deep you delve, you reach the spring below. The more you learn, the freer streams, the wisdom flows. That means you're deep, you dig the sand, spring flows. Similarly, as you keep learning, your knowledge keeps growing. That is where our company secretaries keep updated. We have to be with the face, all the thing what we have been talking about it and emphasizing on it. And another thing is that time management, which is important in our profession. Because everything is time. When we go to the LODR regulation, when we go to the ROC, when we go to NCLT, everything is the time based. Monthly, quarterly, 3 days, 48 hours, 24 hours, within 15 minutes of the board meeting. All the things are on there. I go back to Mahabharata. I think Sudhakar is a great, admirer of Mahabharata. He keeps writing lot of articles comparing the Mahabharata. Just also he said, our company secretary profession is like a charioteer, like a Lord Krishna, who was actually a charioteer for Arjun. He keeps writing. Many of you would be reading his article. I keep reading regularly. He keeps actually writing. So here, if you see, during the 12 years of exile period, Pandava, they knew war is going to be inevitable. What they have done, they have managed that time in such a way they were continuously upgrading their skills and kept themselves fit for the war. So that means we have to also make our time management in such a way, because that is why we are talking timely compliance, absolute compliance, not the apparent compliance. Because these are all only things to bring to your notice. It has been there all along, and we need to. With this, I'll start a small introduction. We know what is the company secretary we are. That I don't have to talk, it is only a recap. As a company secretary, we have many things, because as Sudhakar puts it very clearly, we are the one who's associated and who's actually present in the board meeting, and we know what is happening, what is the board is discussing right from the stage of planning till the stage of execution. We are there actually, we have been witnessing. So naturally, doing the right things, advising the things is really our job. Above all, compliance and governance, and of course, maintaining the various records, etc., supporting the board, all those things is there. When it comes to the practicing company secretary, here the practicing company secretary, it is not only that what is assigned, I will do it. He has to go much beyond what we call it, rather than the customer satisfaction, customer delight. Because I have seen, I am really pained to see some certification. Company has prepared and everything certified. Ultimately, when the ROC sees it, the very first and foremost thing, there are error. And the error is also certified as a truly correct. So what is the meaning of certification then? What is actually done? So routinely, we close our eyes, we do that. That thing should not be there. I will not dwell upon much on that. In fact, two things which are happening. One thing is there companies which are not required to have the company secretary. Mostly private companies. And the companies which are required to have the company secretary. Right or wrong, regulator has made it with reference to the paid up capital of the company. But whether company secretary is there or company secretary is not there, compliances are going to be there. Maintenance of books and records are going to be there. Everything is there. But in the case of the companies where company secretaries are not there, these jobs are done by the practicing people. Sudhakar also said it well said. In which case, the practicing company secretaries have to actually educate them, tell them what is the right thing, etc. So that responsibility they have to actually take. Because otherwise, the companies, whatever the cases I'm seeing, there are a lot of trivial cases. I will come to that. The ROCs is passing the things. These all the things would not have arisen if the people have actually taken the necessary care. That is a point actually. So as we go along, we will see that also. And another thing is that we are also having a lot of things because we are representing the company as a practicing company secretaries, various regulatory authorities, and we are filing the form, we are certifying the things, we are involved. In place of the employee company secretary, we are almost involved in every action, everything in that. In fact, we are more or less like a company secretary only to that organization where we are rendering a service. Above all, there is a secretarial audit report. Secretarial audit report, which is brought out, also analyzes. And here, when we talk about the secretarial audit report, people think our job is only to examine the company side, which is not so. In fact, secretarial audit goes much beyond the things when we come and we'll discuss. Because ROC has actually spelled out very clearly what is the responsibility of the secretarial auditor as well. That is also discussed actually. So with all the things, if you know, really speaking, we have a bigger role to play. Let us look what is the perception of the regulators when we come to the ROC and RD. There is an order has been passed by the regional director of Southern Region at Chennai in respect of Madras Fertilizers Limited. This we discussed in the past also. In this case, what has actually happened is some gifts were distributed in the annual general meeting. ROC has taken up the matter and he actually for the adjudication order holding the company and the directors responsible for that, he left out the company secretary. The fine which was actually penalized appears to be on the higher side, so they went on appeal to the order. Hardy, what he has done is he has reversed the entire order. He has set aside the order very categorically. He said the responsibility of the complaint rests only with the company secretary and company secretary alone. He has to take the utmost care on secretarial matters. He referred to Secretary Standard 1, Secretary Standard 2, in this case, it is Secretary Standard 2. And he very categorically issued a speaking order where it says company secretary alone and he will be held responsible for the mistake. It even goes beyond. Once the company secretary is actually appointed, then the directors are expected to assume the company secretary will take care of everything. That is what he says actually in his order. As you know, in the Companies Act 2013, after the 1956 Act has been replaced, we have been actually recognized as a KMP. We are also recognized as an expert. He refers that also. He quotes in his order that what we are recognized, what is the thing. So what he has ultimately done after spelling out all the things, he told very categorically, I am setting aside the order. And he directed the ROC to initiate action only against the company secretary and proceed and penalize him. That is what it is.
Bala, for a minute, can you please go back to a previous slide?
Yeah.
See here, the second bullet, the provisions of section 260 also recognizes the company secretary who is a KMP as liable for such compliances. Several times what happens is I heard that the colleagues say that we are the sacrificial lambs. In fact, if anything goes wrong, it is the company secretary who has been caught first. Now, the regulator is seeing you as a lion and you are thinking that you are a lamb. Now, it is up to you whether you want to see yourself as a lion or as a lamb. So we cannot merely say that by I am the sacrificial lamb and get the sympathy from anywhere. Regulator says that, look, we have empowered you. If you are in service, you are the key managerial person. And if you are in practice, you are the secretarial auditor. Now it is up to you to use your what's called whatever the power I have assigned to you. If you cry as a lamb, then you face that consequences. If and all any non-compliances takes place. That is what my view is. Yes, Bala, go ahead.
And similarly, when we come to the practicing company secretaries, there is a case, it has happened in the listed companies, that is only Sun Pharmaceutical Industries Limited. The ROC has passed order. I must tell you, it is one of the longest order which is running in pages. Here he not only penalized the secretarial auditor for about 1.5 lakh rupees as a penalty, mainly relating to the non-compliances of related party transaction history. If you look at the related party transaction, this is a matter which is actually discussed in the board meetings, which is actually featuring the financial statements. There are disclosures which are actually required. Here he discussing in the order, he elaborately enumerated power and duties of the practicing company secretaries while carrying out the secretarial audit. You must actually go through. He says actually, company secretary who's doing this audit, he has to have the unbiased view of the compliance status of the company. He should actually give his independent views. He should ascertain the transactions genuine. He has listed down what are the areas he has to specifically look into matter. Here, these cases actually on the related party transaction, you can see here. He said related party transaction, excessive managerial remuneration, insider trading, intercompany transaction, merger, demerger, acquisition, IPO, Ponzi scheme, public deposit, transfer, everything. He has not listed any. Not only that, and he goes further. He actually referred the guidance note and the checklist issued by our institute very categorically, that itself running about 3 pages in the order itself. He incorporated the thing, he actually said, the guidance note elaborately talks about all these things, whereas this company secretary who has done the secretarial audit has actually failed to do that. He very categorically says secretarial auditor was required to adhere the checklist. He is required to review the related party transaction. That is what he actually spelled out in this particular order. It's a very, very eye-opening order for the people who are actually doing the secretarial audit. That is the perception and what is expected by the regulator, which actually comes out in this order. I'm sure these 2 orders.
Yeah. Bala, again, I want to say one or two things in the previous slide only. So, see here, in fact, at one time, one PCS, who was a secretarial auditor of a company, was talking to me. What he was mentioning is the statutory auditor, who is also to say about the certain compliances as far as the Companies Act is concerned. One of that is, of course, related party transactions. It may be 186, 185 compliances like that. There are so many things which in the CARO also the statutory auditor has to report upon. So there, what happened is the company secretary was not convinced about the compliances of the company, but the statutory auditor has not qualified that. Now, the company secretary of the company was arguing with the secretarial auditor that, look, my statutory auditor has not qualified. How can you qualify your report? So he says that, Mr. Sudhakar, that I appreciate that when the statutory auditor is not qualifying, how can I qualify? How to go about this thing? I said, like, look, statutory auditor has his own responsibilities, his own accountabilities, and you as the secretarial auditor, you have your own responsibilities and accountabilities. Might be you got the expertise as far as the Companies Act is concerned. And according to me, you have to sit with the statutory auditor and have to ask him by how the company has complied with why he has not qualified. Either you convince him or you get convinced by him. You cannot have 2 reports, no doubt about it. I agree that by secretarial auditor is qualifying and the statutory auditor is not qualifying. That is not a good, healthy situation, neither for the auditors nor for the company. But what I suggested is sometimes whenever this kind of a situation arises, the company secretary of the company, maybe the CFO, the statutory auditor, and the secretarial auditor, they have to sit together and they have to resolve the issue. If it is to be qualified, if it is imperative, the PCS, who is the secretarial auditor, has to put his foot down and he has to ensure that necessary qualification is there. Because here very clearly the regulator says that by you as a practicing company secretary or as a secretarial auditor, you have your own responsibility. The second aspect is about the guidance note. I several times in several forums I have mentioned this. The secretarial standards as well as the guidance notes are concerned. The regulators have given more importance to that than of our own fraternity. Whether it is the guidance notes on RPT or insider trading regulations or independent directors or CSR, whether it is Ministry of Corporate Affairs or whether it is Security Exchange Board of India. In fact, say me 2-3 times the I mean, okay, it has also been said that by your own institute has PIT regulations, the guidance note. Why can't you refer to that? The presiding officer told the PCS who was appearing before him, why can't you refer to your PIT regulations guidance note? I am relying on that only. And our colleague has no reply at all for that. So this is what is happening. So my again humble submission and request to all of the participants is let us give due importance to the guidance notes of ICSI also. Yeah. Thank you, Bala.
Thank you, Sudhakar. In fact, if we go through in this
That's
particular
one
case,
way. Sudhakar, your point of, who that statutory audit, and we also face many times, the practical ways that we explain the statutory auditor that this is the thing why we are telling, and many times being not so special, it's not many times intentional. Sometimes they're misunderstanding, not understanding the depth of the transaction. We are specialized, so they really respect and then they accept. And here also one point comes, that when we go for audit, we ask for auditor's report and auditor says, I will do audit, give audit report after CS audit report. This is always a tussle. So we work out the solution that you give your draft audit report with initial and we give draft audit report with initials.
Absolutely.
But we have to check whether in your draft report any qualification is there, director's report is going to be with that answer, draft director's report. Because everything will be considered in the board meeting. And this is the right way. And we explain them also that, see, you deal with all the accounting transactions and accounts, so you know better the related party and the complexity that you can point out and dig out the transaction. Whether it is required compliance done or not, that will take care. But there is related party from accounts we can very well check, even though not disclosed. So then it is that way worked out. So if this draft audit report is there, then it helps that, both auditors sit and actually if we talk, they accept. That was the comment. Thanks, practical experience.
Actually, it is the responsibility of the company secretary of the company to ensure that he has to provide the draft audit, statutory auditor report to the secretarial auditor and vice versa. And in case of any difference of opinion is there, he is the person who has to ensure meeting of these two people together. And then ultimately they have to come to a consensus. Suppose, say, for example, if the secretarial auditor strongly feels, in fact, Mr. Yashpal Mehta is also putting a question that how will the matter be resolved if the statutory auditor refuses to change his opinion? In what way the PCS bring it to the attention of the shareholders? See, as a secretarial auditor, you don't need to go in line with the statutory auditor. You can form your own opinion based on your own, the way the things are presented to you. Only thing is, you may discuss with the company, you may discuss with the statutory auditor. If they come around, it is fine enough. If they are not agreeing with you, but still you are very strong that you are convinced that it requires a qualification, by all means you do that. You cannot get budged, you cannot be bullied because you have your own responsibility and accountabilities. Yeah.
In fact, in this particular case, one of the argument when it was there in the personal hearing, the secretarial auditor seemed to have said, no, because the statutory auditor has already checked, he has already issued the things, and we presume that all complaints are done, we taken it for granted. That is the answer he gave. That is why he actually spelled out, look at this is the guidance note, this is the checklist, this is what you are supposed to do. That is why these are all the things which are actually featured in this speaking order, daily speaking.
So that is the answer given by you for this. Matter, matter. Good, you have put that argument and how they have got it.
Yeah.
Sorry.
Then we are talking about the adjudication of the penalty. This is one thing which actually a development which has actually taken place. In fact, the central government, they thought, easier way of getting the issue sorted out, etc. The various register of companies have been appointed as adjudicating officers. So when they are issuing the so-called notice itself, they can proceed with the adjudication notice. And whatever is there according to the provisions of the Act, the penalties, etc., can be levied. That has been given to the adjudication officer across the country, which you are all aware of it. Of course, he gives the opportunity to be heard before he decides the issue that is actually there. Normally, you know the procedure, show cause notice is actually issued. The show cause notice may emanate either he goes through the documents which are submitted on the online, or physical inspection which he takes place, or if somebody makes a specific complaint, the investigation of the complaints, or at times they send the notices to the register office of the company, such register office letters which are returned back undelivered, no such addressee, nobody is shifted, etc. Another thing and all, they make a visit, they found out. From all these things, the issue arises. Whatever it is ultimately their finding, their investigations, then they issue the show cause notice. Then we are bound to give the reply to the show cause notice. Then the personal hearing is actually fixed up and they hear you. Then they issue the adjudication order. For the adjudication order is issued, you will have to either accept the order, you will have to make the payment and close the chapter, or if you have a reason to believe, you can actually go on appeal. When you go on appeal, again, you have various options which we will discuss about. And another thing is there, notice when it is actually given, it will, because the Act says what should be the minimum penalty, maximum penalty, or up to the penalty, it is up to, depending upon the severity of the penalty, he actually takes on call. That is one thing. Of course, in the personal hearing, many times it may happen, he will think that based on your reply, whatever you have given, either there is no personal hearing is required. We have many times people say, okay, it is a mistake, we accept it, we go for the penalty, whatever is leviable, etc. Another thing, and all in such a case, a personal hearing may not be needed. Also, that call also he will actually take. But however, in the interest of the natural justice, by and large, the opportunity of the personal hearing is actually given. And of course, if we are unable to attend the personal hearing, etc., he can also adjourn, he can give you a sufficient time, etc. All those things are also there during the time of the personal hearing. If anything missed out to be replied, all those matters can be taken. And ultimately, the ROC issues the order. He is supposed to issue a speaking order. Speaking order means he has to give the reason. What is his finding? What is his conclusion? What are the things he has gone through it? So he issues the order accordingly. That is what he does. And while adjudicating the quantity of the penalty, he also decides what is the size of the company, what is the company's nature of the business, what is the nature of the default, whether it is a first time default, whether it is a repetitive default, or it is done intentionally, or it is mistake, whatever it is, all those things he takes into hand. And above all, how much injuries it is costing to the other people, public, shareholders, stakeholders, etc. That also he takes into the consideration. If that injury is quantifiable, when it is actually either resulting in the unfair gain or unfair advantages, that also he takes into the cases. Specifically, loss to the investors and creditors, he looks into this. And again, there is also a provision in the Act in respect of the small company, OPC, startup and producer company, which you are all aware, section 446B, which talks about 50% of the penalty subject to certain minimum that is actually there. He will examine that also in levying the penalty. So accordingly, the levies penalties. When we come about who are the officers in default, definition very clearly says, definition section of the company site very clearly says who are actually the defaulter. Full-time director, key managerial person, company secretary is account PNP and also a CFO. Many times CFO also get involved in this, especially the CSR related matters and other things. And again, no KMP, then the director who are actually consulted, if not all the directors, or other persons who are charged with the responsibility officers in default. And again, deeming director whose direction the board is actually accustomed to act, or every director who is aware of the contravention because he received the minutes, he participated in the meeting and he consented. So all these things are all very clearly spelled out over the officer at default. Appeal can be made against the order. When the appeal can be made, when somebody has to take a call, if it is required, whether it is a merit based or anything, etc., you can go on appeal, otherwise you can accept the order. But the appeal has to be made in the respective regional director who are actually appointed across the country, northwest, south, northeast, southeast, etc. So they can actually. When you go to the appeal, what happens? Either he will dismiss the appeal total, ground merit is not there. That is one thing. Or he will confirm, no, whatever I have gone through it is okay. ROC order is actually confirmed. Or if he has a reason to believe, he can modify the order. Modifying means he has given you reduction in the penalty, or he can actually relieve somebody who is not responsible, etc. To that extent, he can do. Or he can set us an order and revoke the order and send back to the ROC re-examination. That is what it has happened in the Madras party license case for the re-examination, issue the notice, etc. and other things and all. It is normally known as the de novo adjudication or any other order. These all the things can happen when you go to the appeal. Then there are two issues are coming out. One is the compounding of offences and other is the condonation of failure. I think you are all aware, but still I thought I'll touch upon all this. When you say the compounding of the offences, once the default is actually committed, then compounding can be done. That means instead of undergoing a penalized action, I compensate with the amount, quantum of the money, instead of undergoing a imprisonment, etc. and other things. But here, all the offences cannot be compoundable. Because there are what offences can be compoundable, what offences cannot be compoundable, the law also spells out. So here law says the offences which can be compoundable is the offence which should not be punishable with imprisonment only. If it is the imprisonment only, it cannot be compounded. And again, if the imprisonment and also fine, then also it can be compounded. If it is actually imprisonment or fine, then it can be compounded. But if the word and is there, then it cannot be compounded. So and or make the difference. And again, suppose there is a limit as specified if you want to make a compounding, up to what limit it can go to regional director who can actually decide. And beyond that limit, it has to actually go to the crocodile. When we talked of the maximum amount of the fine, that means what is the amount of the fine which is actually payable for the alleged violation in respect of the particular section in the act where the offences have taken place, that need to be looked at. When we come to the offences that are not compoundable, if it is only with the imprisonment or imprisonment also with the fine, it cannot be compounded. Where the investigation is already initiated, or there is an investigation already pending against the company, those offences cannot be compounded. And again, this is very important, the third one. The offence committed by a company or its officer within a period of 3 years from the date of which similar offence committed by it or him cannot be compounded. Which means if you compound the offence today, next 3 years, you cannot actually go for the compounding for the same offence committed. This is the very important thing. Yeah.
Bala, here one thing, sometimes people have a doubt that similar offense means what? Say, for example, I have a non-compliance with 186. For example, I have given a loan and I charged lesser amount of interest than what 186 talks about. So I went for compounding. So next 3 years, I cannot go for compounding of section 186 related offense or any offense related under the Companies Act, form filing or non-compliance of provisions of the section. What exactly is that?
No. It is only related to 186. That particular offense only. Similar offense means the offense which is connected in the particular section where you are actually gone. You are supposed to, yeah,
So any issue related to that particular section, am I
Yeah.
correct?
correct, you are right.
Whether it is compliance with the provisions of section 186 or whether it is any form filing related issue or whatever it may be.
Yeah, that is right.
Good. Okay.
This is a very important section which they done. The whole idea of putting this section is you take the utmost care, you don't repeat the offense. That is the whole idea seems to be in the mind of the regulators. Then if you actually want to go for the compounding procedure, first thing is you need a board meeting to be actually called. Then naturally, board meeting means you know to comply with the provision of Secretarial Standard 1, etc., giving the notice, agenda, discussion, all those things. You know to also calculate the amount of the fine because what is the relevant section, that is very important because it will go to respective authorities. Then board has to pass a resolution saying that yes, the board is giving approval for the compounding of the offences. You have to authorize somebody who can actually file the compounding application. Either in a case of the private company, normally it is a director where company secretary is not there, otherwise the company secretary, or it can be any other person, even the practicing company secretaries also can be authorized, whosoever you feel like. Then you have to prepare the compounding application and it has to be prepared as per the NCLT rules actually. Then everything is to be filed on the online. Because there is a procedure after filing the online and GNL form, the physical copy has to be actually handed over virtually because the original documents where the certification, affidavit, notarization, etc., you can file a scan copy. The original is required to go to the office, so you have to lodge it physically in the ROC's office. That is actually required. Just giving a physical copy does not mean you file the compounding application unless GNL 1 form is actually filed. In fact, they insist nowadays, not only that, the GNL 1 form, what is filed along with the SRN number, that photocopy is also required to be attached and it has to be lodged with the physically. That is what they do. That is the method. When you are
I
actually,
think there are two participants who have raised their hand. For them, let me tell that we will open to talk for participants to talk only at the end of the session. Meanwhile, if you have
I'm writing the same message only that.
okay, great.
That
Fine.
means, you put in a chat box only for better administration. You will understand so many participants is there. If you allow in between to speak, then it will be difficult to complete the presentation. Put it in our chat box. We'll take it. The suggestion. If required, surely we will give it. And don't worry if we are not able to finish it, we will extend it. But please note that next week we are not there. We will back in April. Okay. Yeah, Ms. Bala, go ahead.
so when you talk about the compounding application, there are requirement of the documents. Detailed petition is to be filed. Affidavit verifying the petition is to be set. When you say the petition, you have to actually state about the details of the company, the subject, article, memorandum, related things, the directors who are associated, the offences, what are actually happened. All those facts you have to actually put up there actually in that. And then you have to make a verification affidavit in the form of the affidavit. Then you have to actually also give a memorandum of appearance in the form of the Wakalat Nama, along with the certified copy of the board resolution, giving authority who will appear. Many cases, what happens is normally we prefer to engage a practicing people. We normally appoint a practicing company secretary, or some people appoint a law firm, etc., and other things and all, or even we can also appear on ourselves if we are confident enough. Many cases with us, I did appear in some of the cases where I was actually associated. Then again,
there is one question. Bala, there is one question that the words used for compounding is fine, whereas the words used for adjudication is a penalty. Does it mean that wherever the words penalty is used, like non-filing of annual return can only be adjudicated through adjudication process, and company cannot go for compounding? Please clarify.
No, it is not like that actually. In fact, earlier it was actually fine, which they changed to the penalty actually. Now there are two issues. One issue is if the so-called notice actually issued by the adjudication officer, then you can go to the adjudication officer, he can call it. Now suppose you realize on your own, the mistake has actually happened, there is no so-called notices and nothing has come from them. Then you decide I want to set right the things, in which case you can actually file the compounding application. fine and penalty, it does not matter. Actually, it is not that the fine is there, I cannot go, penalty is not there, I cannot go there. It is not the case. Now, for give you an example, suppose you are required to file a particular form. The form is actually not filed in time. Or rather, you take a case of the appointment of the company secretary within a period of 6 months. Any case you take. Suppose you take a appointment of the company secretary within a period of 6 months. You did not appoint. It has taken more time. You have appointed only after a year or something. Legally, you have the 6 months time, but you are appointed after 6 months. Regulatory action has not taken place, no so-called notice, nothing. But you know, there is actually a non-compliance there for a period of 6 months. Now, you being a good governance company, you want to set right that default. So it is your choice. You can go and file a compounding application. Look here, this is the non-compliance which is actually there. I want to file a compounding application. I am filing a compounding application for this non-compliant during this particular period. The choice is actually yours. If you go in the section says, section talks, it's penalized, penalization. What is the penal section? That is what it talks about. So fine or penalty does not matter, but you can go.
I think if I'm not wrong, ROC can only impose a penalty. ROC cannot impose a fine.
No,
And
fine
can
comes,
be imposed only by tribunal, if I am not wrong.
yeah, that is right. That is right. Penalty is actually spelled out in the respective sections. When he does the adjudication, he goes strictly only by the sections. But when he go to the NCLT, they have the higher power. You are right actually on that.
And similarly, if you see the Schedule 5, if there is a fine imposed more than rupees 1,000, then that appointment of that managerial person will not be automatic. It has to, I think if I am not wrong, it requires central government approval.
Yeah, that
Whereas
is right.
in case of penalty, such restriction is not there.
Yeah, that is right. Because this is one of the, what you call disqualification, which are actually spelled out in the act.
Exactly.
Yeah.
Achha, one more related question, Bala, from Karthik of Bangalore is that our understanding of section 441, subsection 1 is that we may go for compounding to NCLT even if the amount is less than rupees 25 lakhs.
No, that is not so, because what happens is the law actually spelled out who are the authorities. Up to 25 lakh rupees, it is actually RD. Above the 25 lakh rupees, it is actually NCLT. When you go compounding, what normally happens? As I told you, the GNL one form is actually filed along with the ROC. And then you lodge the physical copy to the ROC's office. And if the amount is in excess of 25 lakh rupees, what we normally do, or rather I have done in practice, I'm sharing with you, is if it is beyond 25 lakh rupees, we take a copy of the petition after it is lodged with the ROC office. For the safer side, we lodge the same with the NCLT office, telling them this is what it is actually filed. The ROC will be forwarding his comments, etc. and other things and all. We also tell the ROC office this is what we have done. The whole idea is not burden the ROC to send the whole document to the NCLT, only restricting himself to send only the comments related thing. That is what it is done. This has been, I've been doing it when I was there with the Vodafone group of companies. So the law is laid down very categorically. Once the GNL one form is filed, the ROC will actually decide to whom to forward, because he is supposed to forward either to the RD or to the NCLT, depending upon the quantum. It is not just because you have gone to NCLT, NCLT will take care. No, it is not like that. That is it. So here again, whatever the show cause notice you have received, that is also required to be attached generally. And then any other relevant documents, what you feel in this, that is required to be attached. These are all the requirements which are laid out. And again, who can actually file the application form when it comes to the application company? Authority is given either director, manager, CS, or any other authorized person. In case of the director, DIN number is a must. In case of the manager, secretary, PAN number is must. In other cases, PAN number or even to some extent, passport is actually accepted. If the applicant is a company, it is generally the director, secretary, manager, CEO, or CFO in case of the Indian company. If it is a foreign company, they normally appoint the authorized representatives. They are actually given the authority, they are supposed to do it. In case of the other individual, suppose the company decide we'll go with the practicing professional like CS, CA, HWA, even the firm, etc., and all those things, they can do that. That is what it happens. Then the hearing takes place before the authority, because they will issue the personal hearing notice, either the RD or NCT, whatever it is. And then they also pass the speaking order here. When they order the speaking order, the order is not generally issued. The order is actually spelled out. When the order is spelled out, we are actually supposed to make the payment. And then we will have to give the SRN detail to them, which is also incorporated in the order. As directed, this amount has already been paid with this SRN number, so and so, so and so. Then they issue the order. That is what it happens in case of this applications. Continuation of delay is altogether the different matter, because continuation of delay normally comes in cases where we are required to file certain forms, e-form, documents, etc. But we are not able to file in time. When we are not able to file, you know that if you go to the site says that the time is already expired, you cannot file it. Because when the law was actually introduced, they were actually allowing what you call immunity of 270 days initially. 30 days was available, and 270 days were more available at that particular time. So that means a form which is delayed, it can be filed with the payment of the delayed fee, which is calculated on a monthly basis, and we were able to file it. Now that the 270 days is actually done away with them. So in which case today, if you want to file a form, suppose DR told you have not filed, MGT 14 you are not filed, or annual return is not filed, etc. Of course, annual return and financial statement, there is a separate provision. When we discuss, I will come back to that. But in such a cases that you are unable to file the form, it is delayed. Company has actually realized. No action has emanated from the ROC. So when you decide, okay, I want to set right the compliances, there is a avenue which is available, what is known as the continuation of delay. You can actually approach to the central government. When you go to the central government, you have to make an application. We are erred in filing this. You have to put up the case, you have to put up the reasoning, and then you have to see what you call, I may be permitted to file this form after the delayed period. I report the continuation of delay in filing the form. That is a procedure. The government, if they have the reason to believe, of course, the order they will issue. They will record the reasoning in writing. They will condone the delay, in which case we will be able to file the forms. That is the procedure of the continuation of delay here. So here also again the board meeting will be required, approval will be required for filing the continuation application. Continuation application will be filed only the central government. It can be filed on the online. And again, authorization, either director, CS or any other person. By and large, most companies, they give the authority to the practicing company secretary who does the job. Even we have done also. And then you'll have to file the application. Documents, which is the making the application for the continuation of delay, that means you have to spell out what is the document which you are not filed, etc. Full copy of the board resolution. Then the reason in brief, then affidavit identifying, memorandum of appearance, these are the things which will be required. Then CG will scrutinize the application, gives the personal hearing notice. After hearing the personal hearing, the order will be actually issued, either accept or reject, whatever it is, it will happen. By and large, if the sufficient reason is there, continuation of delay is actually granted. Once the continuation is approved, the necessary filing could be done actually. That is one thing. And then you'll have to actually file the form. First, what you'll have to do, you'll have to also file the order issued by the central government in INC 28 form, along with the documents, and they will specify what is the amount of the fees. Here they talk about the fees, how much fees, that is delay filing is called the fees. Here they don't talk about the penalty. So that is to be actually paid as directed by the central government, and the company can file and set right the things. That is what it happens in this particular case. Now, another thing when we talk, although our topic is relating to only to the adjudication order passed by the ROC, we also should not forget that we have another regulator in respect to listed companies. In fact, yesterday when I was discussing with Sudhakar, it was actually Sudhakar's idea. He told me actually yesterday when I was talking to him. It is after Sudhakar's idea, I incorporated this particular slide section. Thanks to Sudhakar. Because in the title was only adjudication, Varusi order.
Yeah, see, though initially we gave the title like that, but I thought that why not to take the opportunity so that the participants will get benefited with your knowledge on this aspect also. Yeah.
So here what happens is, apart from the Companies Act regulator, the people who have gone for listing by virtue of the LODR regulation, the contractual obligation entered between the company and the stock exchanges, SEBI regulates the non-compliances relating to LODR regulation. N number of compliances which are actually there, including the Companies Act regulations, disclosure regulations, then again, price sensitive information, insider trading regulation, many such things which are actually there. So I thought some of the few cases I'll discuss initially, which is arising out of the market regulator caused by either SEBI or SET in brief I'll touch upon. So here what happened, this is one of the case. This is a case actually happened in the year 2019, which is the Bruce Laboratories and the Limited. Here what has happened initially, order was actually passed by the adjudication officer, but the matter went to SAT. The question which has actually came to them in respect of the prospectus, the disclosement of the material information making the false or misleading statements, whether company secretary is also liable for that. That is the question which actually came here. So here the SAT actually said company secretary is liable only for the violation under the prohibition of fraudulent and unpaid practices relating to security market regulations and also ICDR regulation. So when SAT, while passing the order, they actually said very clearly the responsibility of the company secretary, who is also a KMP, is responsible to a much higher level, which is actually as that of the director's level. That is what the SAT actually spelled out very categorically here. Because initially the penalty levied by the adjudication officer was 11.80 crores, but in the appeal, the quantum has been actually reduced. But nevertheless, they also spelled out here what is the role and responsibility of the company secretary. Company secretary is being a person, he is part and parcel of the board, he is equated to that level of the responsibility he actually holds. This is what it came out. So we cannot say, oh, although law says, I am not responsible for this, this is looked after by the other people, board taking a decision. All those arguments have been put up also, but that has not been accepted actually. So here it is interestingly, this is what it has happened. The company itself is initially levied 1 crore, whereas the chairman, managing director, CEO released 3.5 crores, and chief financial company secretary levied 15 lakh, total 11.80 crores. But in the modified order, it has come out like this, whereas you can see company secretary levied for 5 lakh.
Actually, Mr. Bala, nowadays, if you see the trend, the regulators are targeting professionals like company secretaries, CFOs, and, they are made to pay, that penalty personally. Now, this has happened, since we got this new listing regulation. I remember earlier it was only a company and the directors, were penalized. But now the trend is the regulators are after the, professionals. And I've seen some of the professionals, probably they are sticking to the company. Look, I met somebody just last year. I just asked him, like, you're working for a company. He said, yes, Atul, I'm working for this company for almost 15 years. And then I said, jokingly said, time for a change, He said, Atul, I wanted to change, but the last year only the SEBI has levied a penalty of, some 25 lakhs to him. And he's just waiting that promoters pays that penalty and just he will get out of the company. Anyway, so what I'm trying to convey, the regulators is now after the, company secretaries or, CFOs or KMPs, if, something is done wrong. Yeah, Mr. Bala.
No, I'll tell
In
you one
fact,
thing.
in fact, just to add to that, what Atul Bhai has said is that, in fact, some cases, they are clearly writing in the order that this penalty on the company secretary has to be paid by him. Because if the company, what is the reason for that is by that the kind of importance what the regulator is giving to the whether company secretaries or CFOs or CEOs, They say, ki, bhai, it is your responsibility. You have to ensure that if the company is paying your penalty, means what? You will always be the negligent only and you will never be vigilant enough. That is number one. Number two is that under certain provisions of the Companies Act or on the other regulations of SEBI, it is the responsibility assigned to the KMP, the company secretary or CFO, whatever it is. Say, for example, in case of PIT regulations, the window closure decision is of the company secretary, who is the compliance officer, not of
Yeah.
the board. So board cannot, suppose board, if at all they say also, ki, bhai, don't close the window. The managing director says, or the CEO says, don't close the window. Then the company secretary says, I know I won't close the window. Because closure of the window is the responsibility of the company secretary. So you have to put your foot down. You say that, look, I have some responsibilities as a compliance officer of the company.
Yes.
And convince your seniors by that, look, I am duty bound to close the window. Otherwise, you give me the orders in writing that I'm not supposed to close the window. One way of what's called safeguarding yourself is ask your that whoever is the senior telling you don't close the window, please give me the orders in writing. Now the question is whether I can go confrontation with my senior. They may throw me out of my job. That is always in the back of the mind of any employee, no doubt about it. But would you like to forego your job or would you like to end up in this kind of difficulties? So my advice always is that whoever is the compliance officer at that point of time, you have to ensure in such a way diplomatically, you have to approach the issue tactfully also. And then anybody, whether your superiors, they have a reason if they are asking you not to close the window. At the same point of time, it is your responsibility to apprise them under what circumstances you are supposed to close the window. Might be with your maturity, you want to close it, but might be sometimes when it is not required. So get educated at that point of time. Don't be stubborn. Consult somebody else, maybe your legal counsels, maybe some other senior company secretaries or practicing firms take a legal opinion. So don't be that stubborn without proper understanding also. Sometimes it may so happen that you are putting your foot down without having a proper knowledge. That is also not correct. Company secretary should not become an impediment to the company. At the same point of time, company secretary should insulate himself and to safeguard his interests also, for which better to take a legal opinion at that point of time from any PCS form or from any kind of suppose legal form, so that you are insulating yourself tomorrow if the regulator questions you under what circumstances you are supposed to close the window, which you are not close the window for trading, then you should be able to produce this. That will come to your rescue.
Yeah.
See, another thing is there. Law actually says any penalty which is actually levied upon FKMP is actually to be paid from his own source of income. As Sudhakar puts it, if we see many of the adjudication order passed by the regulator, it very categorically says, in case of the individuals who are actually penalized in this case, they are required to pay the money from their own funds, own source. That is what it very clearly says. It is very clear. It is not the question of targeting or something. It is the question of making you responsible. If you don't do your job, you are actually open for the penalty. Somebody else is not going to actually bail you out. That is the whole idea, which actually comes out. Because you see, there's a sea change has taken place between 1956 Act and 2013 Act. In 1956 Act, suppose there is a allotment has taken place, it is delayed and all. What was my responsibility? No, so long I refund the money with the interest, I have done away with that. Nothing else. That was actually in the 1956 Act. But in 2013 Act, that is not so. Apart from refunding the money to the investors, you have done the non-compliances for which you will have to liable for pay penalty. That is a change which has actually taken place between the 1956 and 2013. And again, 1956 Act, the company secretary were responsible only for the offences which are arising under the Companies Act. But in 2013 Act, it is modified very categorically saying that the company secretary not only comply with the requirement of the Companies Act, but also all the other applicable acts in the organization, he has got the duty bound to ensure the compliance. He need not do himself, but he has to ensure the compliance with the help of the board. That is a sea change which has actually taken place.
In fact, you see, Bala, that I always say, as you rightly said, the company secretary's role under the Companies Act 1956, under the Companies Act 2013, there is a sea change. Now, the company secretary cannot say that, okay, look, I don't have any powers, please sympathize with me. Those days have gone. The regulator has given you enough recognition, enough powers to you. It is up to you how you will exercise those powers and how you will conduct and navigate yourself through the compliance culture of the organization. Number one. Number two is that he has to sensitize the board as well as the other seniors about the compliances, whether it is under the Companies Act, whether it is under the SEBI listing regulations, even whether it is under the other what's called as applicable laws also. He should not confine his role only to the Companies Act or SEBI listing regulations. How about other compliances? Because he is the person as a compliance officer giving a certificate to the board of directors at the board meeting that the company has complied with all the applicable laws to the organization. So how he is ensuring that? So he has to sensitize that, at least if not the entire act, the important compliances, wherever they are there, the consequences are very bad. He has to do that. So from time to time, it is the responsibility of the company secretary. Maybe he may organize some training programs for the board, for the senior managements. Sometimes it may so happen that they may not listen to the company secretary within the organization. So under the listing regulations, there is a requirement that familiarization program, training program for the directors. And this kind of seriousness has to percolate from top to bottom. It should be a top-down approach, not a bottoms-up approach. So company secretary has to take some kind of pains to sensitize all these people. Yeah.
There is another case here. This is again decided in 2017. Here again, what happens is the question arises here. This again matter went to actually SAT. So here what happens is the company secretary who was actually held responsible initially, but the SAT actually gone through saying that the company secretary was actually authorized to comply with the obligation related to deemed public issue. The argument saying that the company secretary ought to have been complied with the libel, that cannot be actually accepted, because there has got to be a nexus between the offense committed offender. That is what they have said, because the company secretary in this particular case, he was actually not involved in this issue. But they say law says, no, the company secretary is actually authorized to comply with the regulations, obligations, etc. That is a stand taken by the adjudication officer. But when the matter went actually, then the SAT actually examined, said there is no nexus actually between this issue between the company secretary, and as such the company secretary will not be liable on that. In this case, they said very categorically, the company secretary is actually restricted to refunding the money only here in this, because the matter has been already decided. He was only assigned the job, nothing else is there. So the nexus is not there. That is what the thing they have said. So they told the company secretary initially was made 5 lakh penalty. That has been modified to the nil, but at the same time, said company secretary still got a job to do. What is required to be complied with him under the company's act, he has to comply with that. That is what it has happened in this particular case.
Hello, one question comes. Just go to the previous slide, please.
Yeah.
See, if we see that whenever they go for appeal, okay, suppose SEBI has imposed 5 lakh rupees, and when they went to SAT, they have made it virtually nil.
Yeah.
And in the previous case where you have mentioned that ROC has imposed about 11 lakh rupees penalty, I mean, I think that is also a SEBI only, 11 lakh rupees to vis-a-vis that 1.87 lakh rupees.
Yeah.
So, and the same thing happened with the MCA also, when the ROC is imposing some very high penalties and RD is reducing it to minimal. Why it happens that at the first instance itself, why they impose so high penalties, and when you go for the appeal, they are reducing it?
By and large, it is actually seen the tendency at the lower level. to levy the maximum penalty. Although the guidelines are there, as we seen the various factors which is to be taken into consideration, the size of the company, reputation of the offences, and the nature of the default, etc., and other thing and all. In many cases, I have seen they say penalty up to so much. But what happens invariably, most of the cases, almost about 90% of the cases, I can say, in 10% of the cases, some of the ROCs, they go really looking into these various factors. Even the order spells out, I have taken into consideration these factors, and accordingly, I am levying this penalty which will compensate with the offense. They spell out. In most of the cases, almost about 90% of the cases, that is absent actually. If you see the factors I have taken into consideration, that clause is not appearing actually. So what they go by and large, probably it seems to be the revenue collection method, I will say rather, they impose the maximum penalty. When you actually go to the appeal, the RD appreciates whatever the things are there based on the merit and the representation made at the time of the personal hearing. That is where the reduction takes place. That is what it is saying.
Another thing comes to my mind is that at the lower level, they play safe. Better to impose maximum penalty and let the appellate authority takes care of that. Otherwise, I may be, tomorrow I may be questioned that why you have imposed a lower penalty. It may be, I don't know. Maybe
See, I'll tell you,
just
in couple of cases, even with the lower penalty that he has levied, people thought, no, there should not be any penalty. They have gone on appeal. But straight away already confirmed. No, whatever you have done is correct. I confirm the order hereby.
Okay.
That also has happened.
But Mr. Bala, one observation that they have made severally and jointly liable CS for refund of 40 lakhs.
Yeah.
Now that is taken by company. Now, actually practically speaking, that to refund that, the company should refund. The CS can be facilitator for refund, but see, he is made liable jointly severally. So till the time that is not refunded, he is in a problem.
That is true, because he has to see that compliance is actually done. Because if they are not doing it, he cannot be a spectator. The whole idea is, oh, it is a company responsibility, I keep quiet. That should not be the case. That is why they made it like that.
So let's come to the point that if there is a situation of violation like DIN public issue, this is really a big challenge, and I know many CS who have suffered because of this what is liability is mentioned, refund. So I will suggest, I know the many cases, they have kept quiet at the time of DIN public issue. So at that time, DIN public issue, CS should protect themselves by putting their foot down and all that. If not, this down comment of set of refunding friends, it is miserable. It makes your professional life miserable. So request at the time of DIN public issue, as a CS, you put your foot down, protect yourself, putting in writing the necessary communication. If required, disconnect if the company does not listen to you after necessary precaution for you. Because that's a comment I will surely like to make. Thanks.
Well said, Dipti, well said.
I agree.
This is again another issue which is actually coming out of what we call insider trading regulations. In the insider trader regulation, what has happened is here, a company secretary has actually tendered the resignation. And she was actually serving during the notice period. When he was actually serving the notice period, company did not involve her in conducting the board meeting, etc. She has been told, okay, you attend to the pending work, etc. Work on the handing over the charges and other things and all, whatever is there and other thing and that. We will take care of the routine matters and other thing and that. She was actually disassociated even in conducting the board meeting, etc. and other things. That is what it has happened, really speaking. So what has happened? There are certain issues which came out of disclosure requirement relating the insider trading regulations. But the adjudication officer said, no, the company secretary is actually responsible because she is a KMP, she is a compliance officer, etc. and other things and all those things. So in this case, AO has levied 50,000 rupees per annum. That is what it has happened in this particular issue.
So here
And,
also, Bala, I say it is very clear that SAT in this case found that there existed sufficient evidence to show that the compliance officer was not involved in the fraud.
Correct. That is what they are using the word nexus. The
Yeah.
nexus
So,
between,
So during the notice period of any KMP who is a company secretary, you have to ensure that by a verbal order of the CFO or to whoever the person you are reporting to, by TK that during this period you please sit aside, you don't need to do anything, something like that. We will take care of the rest of the things. Please get that thing in writing, or you have to have some kind of an evidence, because till the time you are relieved, till the time you are in the chair as a KMP or as a compliance officer, it is your responsibility.
yeah, correct.
Or
That is what-
alternately, you have to have some kind of insulation, so that tomorrow, God forbids, if it comes to the regulator, you should be able to produce that. Look, this is what had happened exactly.
in this case, he was able to show the evidence to them that I have been actually told only work on the handing over the charges, etc. And I was actually relieved from the routine things which they have taken care of. That evidence she had. That is why this order has actually come out. Not only that, because she has to actually fight this case and they have to incur the litigation cost, etc. She actually put up the claim to the extent of 96,000 rupees. She requested the SAT to allow the 96,000 rupees as the expenses what she incurred. And SAT actually not only cancelled that 50,000 rupees penalty, SAT actually said it is reasonable if the company pays 50,000 rupees to her through the litigation cost and also the harassment. That is what it has happened in this particular case. This is another popular case in Satyam, which has happened earlier, but the decision came only much later here. And here again, the insider trading, the closing window, what Sudhakar was actually talking about it. He has not closed the window when he had the price sensitive information with him. This was actually the issue. So in this issue, he was categorically penalized 5 lakh rupees penalty actually in this. So it is very clearly shows it is a responsibility of the company secretary. What he is supposed to do, he is actually supposed to do. But one thing is that this is another case where that 1956 Act provision, this case was actually decided Shankar versus LB. This is the current case, live case rather, you all may be knowing it. Because this is actually Deccan Chronicle Holding Limited. It is relating to financial statements of year way back to 2011, 12, 12, 13, etc. on those cases. In this case, what has happened is actually, they actually said the company secretary, he is only performing the ministerial task. He is actually not doing anything. He is not expected to go to the financial statement and verify the contents, etc. and other things and all. And he is only, after the approval of the financial statements, etc., he is only one of the signatory. And he has to get it done, the signature, etc., and circulate, etc. That is what it has happened. So in which case, he is not responsible for financial related matter. That is the case which actually came out. But as I said, it is based on 1956 Act. This came out from SAT. But what happens is the SAT, while issuing the order, said, in this particular case, CS was only supposed to authenticate the contents indicated and not he has to verify the authenticity of the detail which are put in the financial report. That is what it came out. So it was somehow other believed he is not required to go into the detail, etc., apart from signing it. That is what it is thought. But the problem is, as I said, in the light of 2013 Act, 1956 Act has undergone a change to the 2013 Act. The higher responsibility has actually came. When I discuss also, the company secretary has to ensure all the applicable laws. If you actually go through all the applicable laws means, automatically the accounting standards also applicable laws only because it is mandated. So in this particular case, is a relevant accounting standards Ind AS 107, which actually talk about the disclosure in the financial statement which are required to be made. It was the company secretary has to see whether such a disclosure has been made or not in the light of 2013 Act, he is supposed to ensure that. So this may not hold good. That was the initial feeling. But however, the matter went actually to Supreme Court. When the matter went to Supreme Court actually appreciated this particular matter. Supreme Court set aside the SAT order, saying that you re-examine this order in the light of 2013 Act. That is what it has happened, because the Supreme Court did not agree. Company secretary is actually relieved. He is no way connected with the financial statements, etc. and all these things. Supreme Court did not agree on this. He is equally responsible to ensuring disclosure related things in all the other applicable laws. That is what it actually came out. So SAT order was actually set aside by the Supreme Court. Supreme Court has actually directed the SAT to re-examine the case. It has happened some time back, but to the best of my knowledge, I don't think SAT has actually decided on this case. I don't have the knowledge of the revised order of the SAT so far. I think we'll have to wait. So these are all the things I thought of sharing about the,
This is very crucial case and outcome. That means, because all CS is asking that only, that do you mean that we have to check each and everything of accounts? Because here it was buyback and sufficient provision, reserves were not there. But when they sign that, there are many things which they have to ensure. So it is like CFO, you are also signing. So you have to equally ensure what CFO and accounts head has to ensure. So then it is a dual responsibility, which is a correct argument by many CS. That if you are telling, yeah, in this particular transaction, if it is transaction oriented, fine. But if it is situation when the accounts is signed by CS now, whether CS has to check what actually and what responsible is a big question still today. And if this way we consider that Indian accounting standard and everything, then that CS is expected to check accounting standard.
I will tell you, Dipti, see, under the 56 Act, it was the only company secretary and the directors were to sign the financial statements. Whereas under the 2013 Act, even the CFO also have to sign it. At the same point of time, the company secretary cannot say that simply he wash off his hands. I am only administering my ministerial duties, so I should not be held accountable for that. No, it is not so. In the financial statements also, there are a lot of things. Say, for example, Schedule 1 pertaining to share capital. What sort of disclosures are to be given there? Similarly, Schedule 2 regarding that reserves and other things. Similarly, unsecured loans. Similarly, what's called as Section 186 disclosures in the financial statements. Similarly, applicability of the accounting standards. Like that, there are so many things which comes in the domain of the company secretary. Those things, company secretary has to take account the responsibility. He may not be taking the ownership as far as the figures are concerned.
correct. I agree with you 100%.
He has to take the responsibility as far as the presentation is concerned, as far as the dissemination of the information is concerned, as far as the disclosures are concerned. Company secretary has to go through that. Even in Reliance, when I was there, we used to take care of some schedules like your Schedule 1, Schedule 2, Schedule 3, Schedule 4. It is the responsibility of the secretarial department also. Similarly, notes to accounts, it is the responsibility of secretarial department. No doubt about it, the asset side, whatever is there, that we may not be able to take care. But even in the thing there also, suppose the payments to MSMEs, if it is not there within that given this thing, you have to make the disclosures. And that also, again, we used to see that. So secretarial department or the company secretary cannot simply say that, look, as far as the balance sheet is concerned, financial statements are concerned, we are not to be held responsible. Those days are gone. If the company secretary, that is the one of the reason actually that even in the syllabus of ICSI also sufficient what's called as papers are there on the financial management and as far as the accounting related things are concerned.
Exactly my
So,
point was
yeah,
there.
Dipti, I wanted to submit. See, I'll tell you.
I was telling that point only, that there are many points which CS take care in the accounts accounts and all that. But there is no written clarification. My point was that only. I fully agree CFO and all that. So I said that which portion you are telling Indian accounting stuff, but then there should be bifurcation. Nowhere it is written for this CS is responsible for this year. In that clarification is, I
You're-
think.
You are
maybe
right.
not subjectives, but some guidance.
You are right, actually,
I-
Dipti. But the only thing is, as Sudhakar puts it, as far the figure is concerned, that is, now whatever the statement is showing debit, credit, figure, etc., their accuracy is concerned, it definitely goes to the CFO's responsibility. But when it's come to the required disclosure, when we are talking about the related party transaction. Now, when the related party transaction, I have seen also in many companies, what they do, the transaction is actually live, they are disclosing it. But what is the law says? Law says irrespective of whether you have the transaction or not, the related parties details are to be, who are the related parties? Like, subsidiary company, associate company, their parent companies, then subsidiary company, all those names should be disclosed. This disclosure is required. Who will actually check it? That is what it is coming. Basically, the company secretary has to ensure what are the disclosure. To be very frank with you, Dipti, in one of the organizations, that is the Fuzico India Limited, when I was there, after this, that time, it was class 49, which was been amended actually. I sat with the finance people. We have revamped the entire notes to accounts here to decide what is the company policy, what is the things, etc. Because what happens is dividend. We were only talking about the dividend because that time we are not talking about the dividend received, dividend paid, the dividend not, or all those things. We are actually rewritten the entire notes to the accounts. That is what I have done. So people have to take the responsibility of doing this. As you rightly say, clarity is not the question of clarity. It is the clarity what is required to be disclosed. In this particular
Dipti,
case,
I will answer your question, but Atulbhai wants to say something. After that, I will answer your question, Dipti.
Yeah, I think guidance
Atulbhai, please.
required
Yeah.
from, yeah.
Yeah. Dipti, see what has happened in 2015, the Ministry of Corporate Affairs, they set up a committee. I was fortunate to be a part of that committee when I was a president. So that time also, I've raised this issue on behalf of ICSI. Look, company secretary should not be made to sign the balance sheet, and either it should be two directors and the CFO, and but somewhere the discussion went on, and it says, look, Mr. Mehta, as a company secretary, you should also be responsible the content of the financial statements. Anyway, so probably subsequently also the ICSI has made a representation that look, the signing balance sheet, the company should be the employee company secretary should not be made to sign the balance sheet. Anyway, there was some ego issue that some of the my colleagues said, Atul bhai, अगर आप बोलोगे कि look, the company secretary should not be signing the balance sheet, तो हमारा वो एक one level below हो जाएगा. There was some
See,
argument
Atulbhai,
like this.
let me answer your question. See, according to me, company secretary has to sign the balance sheet.
Yeah.
The reason being, whether we like it or not, in the regulators' eye, company secretary's position is something else. But unfortunately, we are not realizing that for whatever the reasons it is. Okay, number one. Number two is that what is the role of the company secretary in the financial statements? Financial statements are to be prepared as per Schedule 3 now. If I am not wrong, under the old act, it is under Schedule 6. So now company secretary has to ensure that financial statements have been prepared according to the schedule. At the same point of time, under the Companies Act, there are various disclosures are to be given in the financial statements. Those disclosures have been given or not given like that and all. So the role of the company secretary is to the extent of the applicability of the provisions of Companies Act. He is not at all responsible as far as the compliance of accounting standards are concerned. He is not at all responsible as far as the financials are concerned, the figures are concerned. The authenticity of the figures, what you are furnishing it, whether those figures have been window dressed or not dressed, all these things, company secretary is not held responsible. Now, Dipti's question is where it is written, where the line is drawn that for what he is responsible, for what he is not responsible. There is absolutely no demarcation, Dipti. But when the question comes tomorrow, when the board of directors, CFO, company secretary have been taken to task. That point of time, if I am the regulator, I know what a company secretary has supposed to do, what a CFO is supposed to do, what a board is supposed to do. Suppose for any reason, if they are roping me as a company secretary responsible even for the compliance of accounting standards, even to take the ownership for the figures of that financial statements are concerned, I always can defend myself. Okay, that's what my view is.
Sudhakar, only one suggestion, just check the possibility of, carrying out guidance note or something on this subject or like that way. It will be, it is a kind of help to the professionals. Just think, propose in the secretarial standard, SSBM.
As Atul Bhai has mentioned that this particular thing of company secretary signing the balance sheet is there since last 3 decades. He will never be able to find a solution for that. Yeah.
Yeah, Mr. Bala.
Okay. So appeal outcome on this case is still awaited after the site revision the order.
There are two comment on the thing, Mr. Sudhakar, you would like to take? By Mr. Karthik and I don't know.
1 minute, 1 minute. Let me go through that.
Yeah,
Subsection, the Karthik's question, subsection 2 requires ensuring compliance of applicable secretarial standards. Subsection 1 requires reporting only. Okay, which subsection 2, I don't know. He is talking about. Okay, we will ask him when we open the participants can speak. That time he can clarify that. No accounts paper and professional. I don't know what is that. I don't know because when I was doing my company secretaryship, we were having this
yeah.
both in executive as well as the professional also. And if I am not wrong, even when I was in the what's called as the vision committee, at that point of time also, we used to have these papers in the professional. Now, if it is not there, I don't care.
That is by Mr.
There is a management representation note in the audit report. The CS, being the KMP, is deemed to have the representation and therefore shall be held responsible for the misstatement. Please elaborate. You see, one thing is there, whenever the company secretary is held responsible for the regulator, by merely the regulator says something, that doesn't mean company secretary will be held responsible or he'll be absolved from his responsibility. The act clearly says that where all the company secretary is responsible. Say, for example, as far as the compliance of the Companies Act is concerned, company secretary is responsible. Now, 205 very clearly says what are the duties and responsibilities of the company secretary. So, only thing is, if you have been roped in for the things which you are not responsible, you have to defend yourself. Similarly, for the things which you are responsible and you are not discharged the responsibility, then you have to face the music. That is what my view is.
Okay.
Yeah.
Yeah,
Bala,
Mr.
complete your presentation, then we will discuss it further.
Then I also come across the default. You see the nature of the default in the recent ROC orders, what it is actually coming. Agenda is actually reserved without adequate documents. Disclosure made by the director not taken on the record, MVP 1. Date and place in the last page of the minutes is not there. Unnumbered meetings are not there. Distinct minute books are not printed. Pages are not getting initial. Blank pages are not scored out, not initial. And again, instead of affixing the full signature in the last page, that is also initial. Sometimes minutes itself is not signed actually. Date of entry in the minutes book is not there. Either the draft minutes not circulated or delayed circulation of draft minutes. KAC of the directors are not done with the result. The company is unable to file their annual return, annual statements, etc. on those things. If you look at this sort of the mistakes, these are all very, very trivial mistakes. I do not know why it is happening when we are calling ourselves, such a high level of the position, responsible people, expert people, KMP and other thing and all. Such a trivial mistake which has actually happened, I can only see one reason. Simply, we allot some sort of this job to the junior people. We don't even bother to take care of it. We don't even verify it. We don't even check it. That is what I would actually say here. Anything you want to add, Sudhakar?
Yeah, I want to add one or two things. In fact, I used to say always, if any company secretary boldly say that I have a command on section 184, disclosure of interest. What is subsection 1? What is subsection 2 in 184? What is the difference between the two? And how the register is to be maintained under 189. Several company secretaries, with all due regards to them, they fumble in that. As you rightly said, these trivial issues which are there, one of the reasons for that, Bala, is because when I was in RIL, I interviewed some hundreds of company secretaries during my 18 years of tenure there. That point of time, what I realized was that under the old act especially, the company secretaries used to feel shy of saying that I am a company secretary and my duties or my profile is to discharge the responsibilities of a company secretary. Because what under the old act, the company secretary was primarily held responsible is to conduct the board meetings, to maintenance of the registers, to hold that, allocate that the compliances or whatever it is. Only 3 or 4 things what he is supposed to do. Conduct your board meeting or shareholders meeting or committee meetings, maintain the registers, statutory registers, and then, ensure the compliances have taken place. So several company secretaries, with all due regards, whenever I used to ask them, what is your profile? They say, sir, I don't do the routine things that my subordinates will take care of. Why, what you do? He will say anything and everything other than the work related to Companies Act. With that, what happened is several company secretaries have lost their core competency in this process. And 80% to 90% of the time, I used to reject the people because what we were looking in the company secretaries at Reliance was not there with them. Several senior people also. Why? In the process of doing other things, they were losing their core competency. Fortunately, Companies Act 2013 has come to the rescue of this profession, according to me, because I have seen 56 Act also, I have seen 2013 Act also. This Act has given the due recognition, due importance of this particular profession. Now the company secretaries proudly say that, well, I am the company secretary. And then they say, sir, I do this, I do this, I do this, and all those things. There are several things out there what the company secretaries now take pride in doing those things. That's what I want to add.
Okay, as you said, I have a slide on this. Who are we actually? Because whatever you said, I actually summarized.
Okay,
This is what it is. Because you see, our profession is actually moved simply from the conscience keeper and compliance officer to a KMP expert, and we are known as governance professional. I am sure, Sudhakar, you are also a governance professional. I am also a governance professional, according to the UK Chartered Secretaries Institute, which has now changed to the Governance Institute of UK. In overseas, many institutes of company secretaries have changed to the Governance Institute, and no longer they are known as the Chartered Secretary. They are all actually known as the governance professional. Now we too are actually governance professional. I think in this group there will be many more people who have done this. They will be also there. So one thing is which is very coming out here, whatever you say, whether it is subordinate, junior, senior, whatever it is, one has to ensure the absolute compliance with the applicable law. That is what it is expected actually here. So how do we do it? There are various ways of doing. One has to find out their own way. Either you can work with a checklist, or you can work with the maker checker system, or you can periodically revise, or you can do what is to be done before, after, during, all those things at the event. Ultimately, the end of the day, the insurance, the compliance is actually required. Many times the counter checking is to be done. We cannot just leave alone. As Sudhakar puts it, oh, my subordinate takes care of. You cannot leave alone like that. That is what it is actually required. So really speaking, company secretary cannot afford to pay the less attention, especially when it comes to the minutes writing, recording, etc. and other thing and all. These are all very thoroughly, very properly, it has to be done. Any lapses is definitely going to take time, money, and financial liability to the company, to the directors, to the company secretary himself, That is what it is actually going to happen. So ultimately, one has to take the utmost care and ensure the absolute compliance. That's on the same point what Sudhakar has actually said. I have nothing more to add. Now look at this, some of the cases here. I just listed down. This is the case. MVP1 in this particular case is a very recent case. In 2023, it has happened. It is not taken on record. Who was penalized here? Here actually the KMPs have been penalized. CFO and CS. Now CFO also can ask how do I confirm the company secretary position? That I do not know. But unfortunately here it is the KMPs. KMPs have been held responsible in this particular case.
Yes.
And then second thing, KSC, non-compliant, the KSC was there. In this case also, you can actually see. In this case also penalty, but here there's no company secretary there in this company. But the penalty has been levied to the company and also the directors. And then again, here is another case. Distinct minute books are not maintained, board and committees, etc. Everything is on, whereas the SS1 is still required very categorically. They spelled out here. Here also the same thing has happened. And again, look at the another case which has actually happened, unnumbered meetings, undated, undated side of the minutes. Again, their regulator is referring everywhere secretarial standard. You can note that I already put here actually. Not only secretarial standard, they are also mentioning which class of the secretarial standard under which the compliance is not done. To that extent, they are actually putting it. So I said in the beginning only how the regulator are actually taking in these issues. This is the thing. And again, if you actually look at it here, you can see here also, there are actually each page not initialed by the chairperson. Not paginated the minutes. Another issue. Not circulates the dot minute, delayed circulation of the dot minutes. So these sort of the things are really causing a concern actually. Because if I look at all these things, I do not know what is the thing. Let us look some of the order. In fact, multiple cases have happened. I take one issue here. In this particular issue, what has happened is the registrar companies have come up. The company is not going to the statutory book of account, minute book, and non-submits of the financials. This order is actually passed by the ROC. What has actually happened in this particular case is the company, the letter has been sent by the registrar of companies to the company's register office address, and it is just returned back. When it is returned back, then somebody went and visited. No such address was there, no such office was there. So emanating out of that, they have actually said since the office is there, this office is not maintained. Books of accounts of certificates is required to be maintained. This office, obviously, it was actually not there. Naturally, minutes book, general minutes book, noting, nothing is there. Statutory register not maintained, which is supposed to be in the thing. And again, on the online, they have gone through, they checked out. Even the financial statements, annual returns have not been submitted. So with the result, they have issued the notice, they have sent out. Ultimately, this is what it is resulted. In each section, you see the amount of the penalty. Anyway, here there's a company plus 8 directors, and we have the details of year-wise. Actually, it has constantly happened for about 3-4 years. That's it. Similarly, there is another case. A private limited company has been converted to a public limited company. When you convert the private limited company to the public limited company, naturally there are a lot of compliances which are required once you become a public limited company. Unfortunately, here that has not happened. Either in terms of independent directors, or either in case of the appointment of the audit committee, or in case of the reconstitution of the existing audit committee with the independent directors. And again, what you call nomination and remuneration committee, all those compliances not taken. And all these compliances are not taken place. They have taken an issue, and it was actually reported because probably what has happened is a private limited company converted to the public company. Nobody realized these are the compliances which are required. Only thing is, unfortunate part is there's a company secretary is there in this company. That is the issue here. So this is the penalty which has been levied by the regulator.
I think in this company there are 2 company secretaries, present company secretary and past company secretary.
Correct. Because the compliance not happened more than 2 years. In
Yeah.
between, the company secretary has left. So naturally, the present company secretary as well as the past company secretary, they have been actually penalized.
Yeah.
So these are all the penalties which has been levied actually from time again. You can see that. Again, the compensation, what you call CSR committee was not constituted, the company was required to. These are all the issues which are there. This is the amount. Again, Atul Bhai made a point. They have to pay from their own pocket. In these cases also, the amount is to be paid from their own pocket. See the amount of the penalty. 2.65 lakh rupees for the company secretary, past company secretary, 3.5 lakh. Then again, there is some ECM, AGM mismanagement. Here also, there are a lot of things which has actually happened in this company. What they have done is they have not circulated the notice to the members and the directors for the AGM. This is the issue which actually came out. And again, annual audited statements with the auditor report, etc., which has not been circulated. And again, what has happened is, not only that, they have recorded the minutes also, it is approved, whether reality it is not approved. I don't know how this can happen actually. Because in the meeting, they have recorded, the minutes have already been approved, which was never the case actually. And again, the financial statements and annual return has not been actually filed. So here also they have spelled out very categorically the non-compliance of SSO in terms of the notice of the meeting issue, etc., and other thing and all. This is what it is real. Here also the company secretary is there. I really fail to understand what our professional people are actually doing. This is it.
This is very scary, huh, Mr. Bala?
Yeah. See, the thing is, nowadays, left and right, they are looking into the thing because nowadays on the online submission, they are able to find out. It is not necessary. Gone are those days when people used to come for the inspection, they used to take the inspection, etc., and other thing and all. Now that is not required. Inspection is only called for when it is required. Otherwise, they are actually going through the online. They are simply sending an email. They are calling for the inquiry. They are finding out the details. If at all required, then only they do. The inspection normally happens only when, the address is not there and the letter is returned back, etc. They take the physical inspection. They verify whether the register office is existent, not in existence, etc. Only those cases the inspection was taking place. Otherwise, inspection is not there. And again, if there is a specific complaint has been actually made, then the investigation actually they do it. These are the things which are actually taking place. So here also this has happened place because MGT 7 has not been filed, AOC 4 form has not been filed. All the things they can find out on the online, that is what it has happened. The fine penalty is actually reflected in this particular case. Question is, when the company secretary is there, the things are taken. That is the whole issue. And another thing is there, one of the year, they have actually given the exemption for 92 and 137, that is filing of the financial statements and the thing, because what has happened, somehow that particular, the company has actually filed the filing immediately after the show cause notice has been actually issued within 30 days. Because the law has been actually amended sometime in the year 21, specifically giving the exemption to this two statement, that is filing of the financial statements and the annual returns. If it is actually filed before the issue of the show cause notice, or even if it is filed within 30 days from the issue of the show cause notice, in such a cases, then it will be taken, a compliance is actually done and no penalty will be levied. That is actually saved in this particular case for them. This notification is there, meaning everybody is aware of it. So this is another thing. So now let us look into specifically some of the cases. I thought I'll list down some of the cases which is relating to delay in filing the commencement certificate, non-maintenance of register office, non-mentioning of the address and register office in the SIN details, not sending the proper notice to the board meeting, notice issued to the AGM without financial audit report, failure to make disclosure in the explanatory statement. Then in respect to the board meeting, certain non-compliances, not holding the board meeting within the gap of 120 days, not holding 4 board meeting as required, failure. And again, minutes, These are all the certain issues. We can just glance through this. You can just see here. This is the particular case. In this particular case, the commencement certificate has been delayed. They are not filed in time. Almost about 16 days it takes. So it resulted in the total penalty of 3.5 lakh rupees, company 50,000, and each directors. That is what it has happened in this particular case. Then again, this is the non-maintenance of the registered office here. This is a very interesting case because what happened is in one of the Bangalore hospital, they have actually obtained a post-back address, care of post box. They did not have any office actually as such. So this continued quite some time, certain years actually. And when they actually found out, then they checked out where this office or the thing, they said, no, we could not get the door number, we could not get this, we could not do this. All these excuses have been actually put up. But finally, they have shifted the year 2018 after they incorporated the company way back in 88. So during this time, the ROC has actually said you have not been maintaining the registered office of the company. Of course, in this company, CS was there, CFO was there, ex-CFO was also there. So all these people have been actually penalized in this particular case. Of course, they went to appeal in this case. Sudhakar, you may be interested in knowing. The 8 lakh rupees penalty has been reduced to 1.60 lakh rupees in this particular case when they went to the body. That is what it has happened in this particular case. Then this is another thing. The SIN number, company registration number, and all those things are not mentioned whenever we have the communications. This is the thing. Here it is what happens. There is somebody has actually complained that the office SIN number is not available. This is not available and all. They have found out. They actually noticed the communication which is received by the ROC. They also do not contain these details. So ultimately it is there. But only thing in this company, what has happened, it is being a small company. In the normal case, they would have paid 1 lakh rupees penalty because it being a small company, the law says out of the total amount of the penalty, 2 lakh rupees is restricted under the 446. We say that is why they'll have to pay 2 lakh rupees. Otherwise, it would have amounted to only 1 lakh. Then again, the proper notice was issued in the board meeting. This is exactly the point here, what you write, Sudhakar. In this company, independent directors have actually raised a complaint. They have not been getting the board meeting notices with adequate documents. That is what it is. Adequate documents are not being provided. That was the issue. This issue was actually examined by the ROC. Adequate documents are not provided while issuing the notice. This has happened again. This was the requirement SS1. They have spelled out very categorically. It is actually the SS1. In this particular case, it is only the company secretary who was actually penalized. This is the ROC order. They are recognized. Nobody else's fault. It is only the company secretary. It is the company secretary alone is actually liable for it. That is what it is finalized in this case. Then again, this is another case. Financial statements and auditor report is not sent. This is again SS2 non-compliance which has actually happened, but the company realized their mistake. They themselves have filed the sumoto applications. They sought adjudication to be made on this particular case. Here also CS was there actually. So along with the company and other people, even CS was penalized. Then again, the explanatory statement. It is again the complaint made by the shareholders because they specifically not said when it comes to the appointment of the independent director, they are not given the declaration saying that, the independent director fulfilled the criteria to be appointed as the independent director, which has not been found in the explanatory statement. This was actually taken up with the ROC. ROC investigated the matter. They have found out the explanatory statement was not actually contained this sort of the requirement, which is the required under the law. So accordingly here what has happened, it is actually happened in the past company secretary. So including the current company secretary, past company secretary, and director and company, they would actually penalized. Then again, this is another issue, not conducting the 4 board meetings or the gap of the meeting conducted, which is actually not maintained. In this particular case also, along with the company and the managing director, whole-time director, the CFO and CS, They were also actually penalized. Only thing is non-executive directors were left out. Then again, the same case here also, it is 120 days not maintained. Heavy penalty around 3 lakh rupees. This is a very interesting case because what has happened is somehow that in this particular case, the ROC has actually found out there are various board meetings, approvals, transaction, important things which are actually not taken. He has given the list in the speaking order. If you go through the list, you will be astonished to see this is the list what is actually given. Minute book not serially numbered, purchase of vehicle by the company not been recorded, detail of advance of loan given to the various group parties had not been recorded, details of the remuneration director not approved by the board, not even recorded, details of the employees engaged has not been approved, details of the loan borrowed from the banks and other parties had not been recorded, collection of the funds through the private placement from farmers not recorded, investment accepted, there's a problem. Auditor's qualification made is not actually addressed. Large number of complaints which has been received against the company, which is actually not recorded, not resolved, not found in the minutes book at all. Except for the share application money from the investor not been recorded. No board approval for raising the funds to the private placement. All these sort of the things they actually found out. So ultimately, there's a heavy amount of the penalty has been actually made in this particular case. You can see there. Here also the CS is there, CFO was there. Both of them were taken to the task with being a KMPs. Any comment from Sudhakar?
There are questions, but I think we can take it last. You finish it off
Yeah,
because,
Sudhakar, anything you want to add?
because it's 1 o'clock. So,
Yeah. I think Bala, you wrap it up and let us take the questions and Bala, two people have raised their hands also. Let us allow them to speak.
Yeah.
Okay.
because 1 o'clock only, no, that's it.
Then I think probably we will see 1 or 2 cases and we will stop it because there are many things are there. But I don't think based on the paucity of time. But at the same time, what I'll do one thing. I'll straight go to the last few slides where we are talking about the secretarial auditor.
Yeah, that is better.
There are issues of non-appointment of the women director, non-appointment of the independent director, non-appointment of the company secretary, chief financial officer, delayed intimation of the director resignation. All these cases are also there actually.
I think anyway, Bala, I see that most of the cases are like non-compliances only. Okay.
Yeah.
So only thing is, it case to case, it differs what kind of non-compliance.
Right. There are 2-3 cases which actually came out, Sudhakar. One is actually MSM. In MSM, the disclosure was not there. Was a heavy penalty to the tune of 16 lakh rupees has been actually levied in one of the cases. The amount pending was only around to that tune only, around 14 or 15 lakh rupees, but the penalty levied is about 16 lakh rupees because the disclosure has not been made what is recorded in the financial statement. And second thing is one of the company, the managerial remuneration figures have not been actually kept up. They paid in excess of the remuneration they paid. So there also the heavy penalty has been levied as equivalent as that of the remuneration. I think the remuneration payable was about 70 lakh rupees and the penalty is amounted to some 18 lakh rupees or something like that. These are all the things which has actually happened. Coming to the secretarial auditor, there are few cases I actually come across. One is actually the secretarial auditor violation of the Provision of Companies Act audit report. And second thing is omitting the critical related party transaction. And then defective certification of the PAS 3 and the erroneous turnover certification. These are the cases which I came across. I think this is the first case which has actually happened with the SR Shipping Limited. In the SR Shipping Limited, it is really taking the company not maintain the minutes book for the board meeting and the audit committee meeting as per the requirement of the secretarial standard. Some or other secretarial audit report did not point it out, and not only that, section 186 related complaints, which is also not been actually pointed out. Secretarial report was actually silent on this matter. The secretarial auditor ultimately said, no, it is a inadvertent, it has actually happened. No undue advantages taken place, etc. And all take a lenient view on all those things which he actually pleaded. But the AOC is actually, ROC is actually fined 2 lakh rupees penalty in this particular case. Then this is the second case. In this second case, RPT transactions again. This RPT, the case which I discussed in the beginning only, Sun Pharma case which we talked in the
This is a well-known case to everyone.
Yeah, that is the thing. So in this case, about 1.5 lakh rupees penalty has been levied to the secretarial auditor. This case we don't have to discuss. Again, there is another case. This is actually a PS3 form has been actually filed. When the PS3 form has been filed, what happened is the figure was actually put wrongly. The company has filled the wrong figure, and the PCS has certified the figure as the correct. Wrong certification has been actually. So what they have done is who the signatory to the form. That is what they have found out. It is also a managing director of the company who was the signatory to that, and the PCS who was actually certified. So both of them were actually filed in this particular case. Then this is the third case. Here, you know that the AOC form, which is converted in the XBRL mode, the proper heading it has to actually go. Somehow that the turnover was not reported as the main revenue income of the company. It has gone to some other head actually. It is not, gone to the principal products head actually. It has gone to some other head, some sort of the, what you call accessories, etc. and other thing and all. That is what it has actually gone to. So naturally, the certification has been done by the secretarial auditor. The ROC has taken up this particular matter, and the company themselves have filed the CMOTO application on that. So company was also penalized, and equally the PCS was also penalized. That is what I have with this. Yeah, I'll stop sharing the screen. Yeah.
Yeah. Doctor, you want to take question, or we'll allow the people who has raised the hand for communication?
I think allow the people whoever wants to speak, because the questions I have seen that, but they are not very important as such. That if anybody wants to speak, or if anybody wants to give a feedback, if anybody wants to say something.
I think Amit Singh has raised the hand, and Shyamala is raised the hand. I can see.
Yeah.
As regards PPT, it will be only, uploaded on the website. So please understand that.
Yeah, so we have allowed Karthik, Amit, and Shyamala to speak. Yeah, any one of you can start. Amit, you can start. Amit, you are there? Shyamala? Or Karthik or Ajay Tiwari, any of you, if you are live?
I'm here, Karthik, I'm here.
Yeah, Karthik.
Couple of comments I had posted. One on the functions of the company secretary. So what I wanted to say was the functions of the company secretary as per subsection 1. Am I audible?
Yeah, very much.
Yeah, you are audible.
Yeah, so what I wanted to say was subsection 1, clause A states that the function of the company secretary is to report to the board about the compliance status with the provisions of the Act and other laws applicable. Here, they have not used the word to ensure, which if you see clause B, they have stated that to ensure that the company complies with the applicable secretarial standards, which means the responsibility is cast upon the company secretary in employment in the clause B, whereas in the first subsection, for the first clause, it is only to report to the board of directors. That's a subtle difference between the two clauses.
According to me, it is not so. The reason being, Though they say by that you have to report, that means what? Where you are unable to comply with the act, there only you have to report to the board. Because see, what happens is when you are the key managerial person, what are your responsibilities? You have to comply, you have to ensure you are the compliance officer. So whether it is listing regulations, whether it is the Companies Act, if not you, who will comply with that? Number one. Number two, when you are appointed as a company secretary, the company always say that what is your work profile, and imperative it is for the company to write that you have to ensure the compliances of the Companies Act and other legal provisions, blah 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 and all. Because of that, you will be definitely fall under the what's called as an officer in default also. Apart from that, your key managerial person functions and all. So let us not restrict ourselves by that we have to report and we are not to ensure that.
But one thing is also nicely pointed of difference, ensure, but he is telling as regards accounting standard as ensure, so we have to check that. So my comment on that, whether we are responsible, but that is pointed that it is mentioning ensure, so we are liable that way.
Sudhakar sir,
That
the
ensured-
context of this
Yeah.
discussion was whether the contents of the balance sheet is correct, whether that is to be ensured, where you had also stated that we are only going to see whether the Schedule 3 has been broadly complied and the accounting standards. So, however, we are not going through the details of the correctness of the numbers. That is the context of this.
Correct.
So thereby he is telling ensure word is
Yes.
there, which is very important observation.
No,
Yes.
ensure what?
As far
What
as
is the wording?
as far as secretarial standards are concerned, we are to ensure compliance.
Okay.
Company secretary has to ensure compliance of applicable secretarial standards.
Ah.
Okay.
Karthik, I will put it this way. When you talk about the secretarial standard or Companies Act, etc., this is the company secretary, he has to ensure the compliance himself. When it comes in the other laws, he is not to ensure himself, but he has to see that is ensured, whether it is ensured,
Agreed,
not
sir.
ensured, it is reported
Agreed.
back to the board. He has got the responsibility to get the compliance is actually
agree.
done by the company. That is what he himself need not ensure. But he has to see that it's ensured is done by the other people who are responsible.
I agree. I agree on that with the observation that as a secretarial auditor, when I go, many times I find that, somewhere there is something is missing. The company secretaries in employment, they are not timely reporting. There is a gap. I mean, we point out, and yes, they do start doing that. But from the very beginning, this should have been there ever since this section was notified. That's just observation I wanted to bring.
Karthik, I'll tell you one thing from my personal point of view. This 2013 Act has actually brought all the applicable rules and regulations to be ensured in 2013 Act. But much before that, in the listing agreement, when the clause 49 was actually ensured,
It was there. It was there.
it was actually there. I was working with the listed company. One that was there, what I have done, because we had largely about 5 manufacturing units across the country situated from Pondicherry to Jammu Kashmir to Calcutta to Bombay to Pune. And plus we have almost about 24 stock points with 32 branches. What I have done, I have actually sat with the people. I have prepared the list. What are the acts which are applicable to our company? That time I could list out, it was a medium-sized company of doing about 300 crore turnover. When we found out, almost about 95 acts were applicable. I presented this to my board. My board said, this is all the act you are listed out. To the best of my knowledge, this is the known act. If anything missed out, we will have to find out as we travel along. I cannot say it is 100%. That is the answer. But what I have done is I have taken the help of each and every people. I have actually created a checklist. Suppose labor laws, what are the compliances required? What is the due date? What is the time? I have actually prepared. Those days, computer was not there so much. We did not have it. We used to work with what we call the manual register and the fax machine. I told all the people, look here, this is the compliance checklist for you. This is the day compliance should be done. This is the day it is actually done. At every month end, I need to get a fax copy of this compliance registered to me on my table. I used to get. I used to go through. I used to see whether ensuring done, not done, late, etc. And all this. I used to prepare the report. Every quarterly meeting I used to put up. That is the way I was actually ensuring. Today we are actually much equipped on the online and the digitalization. You know, even if you missed out anything, the reminder comes actually. All those things are all, we should be able to do it. I think a company secretary should take the ensuring part. He has to ensure. He need not ensure himself, but he has to get it ensured.
Thank you, sir. I agree with you. Thank you so much.
Thank you, sir. Thank you, ma'am, for taking this grateful session and guidance. Actually, I have one question regarding those points that yes, it's personally liable. My question is, the company had D&O policy, still will it not take care of that? This penalty and all this cost, legal cost.
Yeah, Ajay, as far as the D&O policy is concerned, it is like insurance policy. It comes with a lot of terms and conditions. And the major thing is that wherever you are negligent in discharging your responsibilities, similarly, wherever you have been what's called ordered as if you are the responsible person, that point of time, D&O will not come to your rescue. D&O is only when you are able to establish that you are diligent, you are vigilant, and you are not what's called as liable for that particular non-compliance or whatever it is. So don't depend upon D&O policy only. D&O policy will come to mostly to the rescue of the independent directors because who are not in the day-to-day affairs of the company. That point of time, they may be able to plead that, look, I am not in the day-to-day affairs. I am not to be held responsible for that. As we all know that 149 subsection 12 is there where it says that if anything happens through the board processes, then he will be definitely held responsible. If anything happened outside the board processes, he will not be held responsible. That point of time, D&O policy will come to his rescue as far as the expenses and other things are concerned. Okay.
Not only that,
Thank you,
as
sir.
far the D&O policy is concerned, mostly the expenses will be reimbursed in respect of the litigation charges, etc. and all those things. If the personal penalties are levied, that will not be reimbursed. Generally, you can go through the clause, whatever you have taken, etc. and other thing and all. By and large, that is what the issue is. Yeah. Deva. Yeah.
So, if articles of association of the company provides for reimbursement of expenditure incurred by the officials, then what about this one? For example, there is a default is there. Of course, it is a default by the company as such. But there is a clause in the articles that the officials can claim reimbursement of the expenditure incurred by them in this case. It is not an insurance policy. It is a company.
Mr. Prabhakar, the thing is like this. As far as your legal expenditure is concerned, if the company is reimbursing that, that is fine. But when the regulator imposes a penalty on you, that is your personal liability, not the official liability. So the organizations are not supposed to pay as far as the penal provisions are, the monetary penalties are concerned. Legalities, whether you are defending yourself as an official of the company, whatever the legal expenses are there, that may be reimbursed. But these days, what happened is some regulators, even they are clearly writing in the order itself that the concerned official has to pay the penalty from his own pocket.
Okay. Achha, one more point. In private companies, say closely held family companies, there directors will be only family members only. Then how seriously it will be taken in routine matters like serving notices within time or enclosing the documents and all those things? So will there be a relaxation or they'll be doing it?
Wherever Companies Act has given you relaxations as a private company or a small company or a one-person company, those are only available. If the relaxations are not there in the Act, the adjudicating officer or the tribunal will view you as if you are one among the same.
One more point, there is no requirement to appoint a company secretary for a private limited company with less capital. But if they appoint a company secretary, then also will all the provisions applicable to these penalties and all these things, will they be taking a strict view or will there be relaxation?
Are you filing DR 12?
Yes.
If the moment you are filing a DI at 12, for all purposes, you are the company secretary.
Yeah, you're a compliance officer. That's all.
Even if you are not filing DI at 12, you are officer in default. You have been entrusted with that responsibility. If I am the regulator, I will hold you responsible as officer in default. So
No,
don't
but-
think that you cannot absolve from the responsibility.
My point is, when Act does not say that company secretary need not be appointed by a company. In such case, I'm saying.
No,
Doesn't
company
matter.
sec-
Doesn't matter.
See,
See,
company
the purpose
secretary-
of that company, the purpose of the company appointing you voluntarily is to ensure that the company is complying with the with whatever the compliances are required. That is what you are meant for.
Okay, okay. Fine,
Yeah.
thank you.
Abhishek, Shyamala?
Hello.
Yeah.
Hello,
Yes,
Abhishek Jain.
Yeah.
मेरा कंसर्न ये था कि जब प्रीवियस कंपनीज एक्ट 1956 में हम रमैया पढ़ते थे तो वहाँ एक क्लियर सर्कुलर आता था कि गवर्नमेंट को लिखा गया था कि फाइनेंशियल स्टेटमेंट या कोई भी चीज बनाने में कंपनी सेक्रेटरी का कितना रोल होना चाहिए, या मैं दूसरे वर्ड शब्दों में कहूँ कि कोई फाइनेंशियल स्टेटमेंट प्रिपेयर करते टाइम या अदर कंप्लायंसेस के टाइम कंपनी सेक्रेटरी के रोल को जो बाइफरकेशन किया जाना चाहिए। मैं एक सिंपल एग्जांपल से बात करता हूँ कि अगर एक गृहिणी है जिसको भिंडी की सब्जी बनानी है तो वो एक स्पेशलिस्ट ही होती है कि किस समय आपको उसमें पानी डालना है ताकि लेसा उसमें नहीं बने। एक एग्जांपल दे रहा हूँ सिंपल। अभी जो कंपनी एक्ट 2013 बनाया गया है उसमें कंपनी सेक्रेटरी की रेस्पॉन्सिबिलिटीज को इस हद तक वाइडन कर दिया गया है, इतना इस हद तक एक्सपोज कर दिया गया है कि वहां पर ये समझ में नहीं आता है कि क्या सिर्फ कंपनी सेक्रेटरी ही एक ऐसा बंदा है जो हर चीज के लिए रेस्पॉन्सिबल है। एक फाइनेंशियल स्टेटमेंट जो चार्टर्ड अकाउंटेंट की स्पेशलिस्ट ही है टैक्स ऑडिट करना, वो एकदम जैसे साइड में बैठ के बेवकूफ सा बिहेव करता है एंड देन जब लाइबिलिटी का नंबर आता है ऐसा लगता है फॉर द सेक ऑफ लाइबिलिटीज ये कंपनी सेक्रेटरी को अपॉइंट किया गया है। तो हमें मिनिस्ट्री को ये लिखकर क्या ये नहीं क्लैरिफाई करना चाहिए कि किस मामले में कंपनी सेक्रेटरी को स्पेसिफिकली देखना है और कि कौन सा मैटर दूसरे प्रोफेशनल्स के ऊपर है, वरना ये तो ऐसा हो गया कि आप शादी कर रहे हैं, सारी रिस्पॉन्सिबिलिटी बहू की है, सास की कोई रिस्पॉन्सिबिलिटी नहीं है।
एक मिनट सुनिए मेरी बात। We have discussed enough as far as the financial statements and company secretary's liability is concerned.
मैं किसी भी रिस्पॉन्सिबिलिटी के बारे में बात कर रहा हूँ,
in that
वहां
regulator
पर
का व्यू है
बीइंग ए कंप्लायंस ऑफिसर इट इज नॉट नेसेसरी कि हर एक चीज, हर एक शब्द, हर एक लाइन कंपनी सेक्रेटरी देख रहा है। मेरा कहना ये है
as a regulator
जब
he
हम
will be
चेक करते
holding
थे
you
तो हमें मालूम क्या कौन सी 5 चीजें 7 चीजें हमें देखनी होती है, लेकिन इस एक्ट में ऐसा कोई बाइफरकेशन नहीं है।
Abhishek, your question is understood. You need not elaborate. I phrase this question. We discuss in that, but as on today, the situation is there is no clear demarcation. We discussed that also. So as on today, what you are telling, we are also telling that in 1956 it was clear. 2013 it is not there, and Mr. Sudhakar mentioned that you are being labeled KMP, and then CFO has started signing. All that we discussed. So we also agree with you that why one-to-one word we have to do. So let's stop it there, but there should be at case to case the things will be worked out. Okay. Okay. Mr. Sudhakar, you want to say something?
Dipti, before we conclude, I would like to say one or two things. Number one, as we always say that the devil is in details only. So similarly here also, after Bala's today's presentation, I can say that the devil is in the trivial matters. So as company secretaries, whether we are in service or we are in practice, we have to ensure that nothing is trivial, everything is important. In fact, that in future, once this version 3 of MCA is going to be completely settled, where this artificial intelligence is going to come, that point of time, in fact, this AI will work out what are the non-compliances and it will throw the adjudicating orders. So one has to be very careful. We have to realize that nothing is trivial, everything is important. Number one. Number two, that the saying that bhai hamara koi sunta nahi hai in the organizations, those days have gone. Company secretaries, according to me, have to realize their responsibilities and accountabilities, and then they have to be assertive. If not aggressive, they have to be assertive, and they have to ensure that they are insulated properly. For which, what they have to do is not the D&W policy will come to their rescue, but what will come to their rescue is they have to sensitize the board of directors. They have to ensure that senior management are also have the faith and realization that compliances are very, very important. Towards which they need to ensure that proper training schedules, training, this thing also to be, I mean, in the internal or external, whatever it is, they have to ensure that. Then at the same point of time, the company secretaries, if they have to make their view present before the board or before the senior management, they need confidence as well as courage, which will come only with knowledge. So the company secretaries have to take a deep dive into their whatever the compliances are applicable to their companies. They have to have a thorough knowledge about that. Now, several people are asking for today's presentations. In today's presentation, Bala sir has nothing he has done. He has compiled a lot of cases into the place. In fact, I must commend the efforts what he has taken to make this presentation. And so I only advise all the participants is to read his articles religiously, and you will come to know about the non-compliances, how the regulators are taking the view and all those things. And according to me, as I mentioned in the initial stage, Bala sir as the Vyasa Maharshi of our profession, with dispassionately, without any kind of expectations, he put all his articles in all the WhatsApp groups. I think if I am not wrong, about 10 to 15 WhatsApp groups, he's posting all these articles. Only thing is, it is up to us. He is serving the food to us like a buffet. It is up to us how much we can eat and how much we can digest. Mere eating is not sufficient. We should be able to digest also. I'm sure that we all will get benefited with his knowledge, with his wisdom, and with his passion towards the profession. Before I hand over that to Dipti, I wish you all a very happy Holi. God bless you all. Thank you.
One minute, Dipti.
I think, no, 1 minute. Mr. Amit and Shamla has raised
Yeah,
it.
okay.
And just two now people and just 1 or 2 minutes and we'll close it, huh?
Yeah, before they speak,
Before
I will say
closing,
something.
I'll give you. Yeah, of course.
Yeah, I'll say something. Since Sudhakar actually said very clearly that I have been writing the article, etc. In fact, I have created the group, article sharing group. Almost about today, 150 people are actually there in that as a participants. Mr. Sudhakar is also there, aspects there.
In fact, I only suggested that.
I am actually putting it in that WhatsApp group. I am sharing the PDF format of the article in that group. In this particular group, anybody is actually interested in getting those and getting enrolled in that particular WhatsApp group, please send me a hi message in 9423013002. I'm repeating the number 9423013002. Just give me your name, give me your email ID. I will share the articles and it will be available on your mobile as and when it gets published. Okay.
Mr. Amit and Mr. Shamla, just 1 minute, please. Be short.
Hello. Good afternoon.
Yeah, you are able.
చెప్పండి.
సార్ మీరు ఆల్రెడీ బ్యాంక్ ఆఫ్ స్టేట్ చార్జ్ ఇది చేసినారు కదా సార్ దాన్ని బేస్ చేసుకుని
Switch off. Mr. Shamla. Mr. Shamla.
Dipti, she is not there. She is not.
Yeah.
We can close.
Thanks a lot, Mr. Bala, for sharing this. Friends, it was wonderful presentation by Mr. Bala. You will all agree. And there is never ending to this cases and all that. And with holiday, long weekend, still we had such a good number of people and so many participants. Thanks for your participation. Friends, we are not there next week, but we are coming with Mr. Sudhakar, you would like to say comment on that April topic? Announce anything?
Yeah.
Mr. Sudhakar?
Only I would like to say that now. Yes, you are able to hear me?
Yes, yes.
Yeah, I would like to say that from 6th of April, that is next Saturday, we are not there. After that, 6th of April onwards, we are going to start a master class on the Companies Act 2013. This is going to be a series of webinars. In fact, we have completed 1 decade of implementing Companies Act 2013. So we thought that let us have a relook right from section 2 onwards up to section 470 or so, which we will be doing over a period of time. So the first, the webinar is going to start on 6th of April. Please wait for the details, which we will be announcing it soon. Thank you.
So be ready for master class. Thanks,
Yeah.
Mr. Bala. Atul, you want to say anything, please?
No, just wish you all, happy Holi and enjoy the big, weekends. Yeah.
Thank you.
Thanks a lot to everybody. Wish
Thank
you a
you.
happy Holi. So
Thank you,
next
Mr.
week
Bala.
we are not going to be there. Next week we will meet.
Thank
Thank you, Mr. Bala, for a wonderful presentation. Thank you.
Thank you. Thanks a lot. Have a good weekend.
Yes.